having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everybody, and welcome to the Appeals Court sitting for September 11th, 2024 in Courtroom 3, the Armstrong Courtroom. Your panel for today is me. I'm Greg Massing. My pronouns are he and him. With me is Justice Catherine Hand and Justice Paul Smyth. We've got a full caseload today, although there's only a couple of cases that are here right now. But I know you two guys know the drill. We give each side 15 minutes. There's no rebuttal in the appeals court. We are familiar with the cases. We've read the briefs. We've brushed up on the case law, and so you can go right into your argument. You're free to use all 15 minutes, but if you've said all you need to say, you're free to sit down early, and there's no penalty for that. We will, as I always say, we have your materials here on our tablets, so we are not looking at the news or looking at Instagram. We're looking at your case materials if we're looking down. So with that, I'm going to call the first case, and although at the moment my tablet is like, for some reason, it has a picture of me on it, which I've got to fix that. Hold on just a sec. Okay, no more selfies. The first case is Commonwealth versus Gregory Oai. You help me with the pronunciation. 23P277.
Okay.
Did I get it right?
That's how I call him,
Okay.
Judge Greg Oai. So Attorney Jason Howard on behalf of Mr. Oai, and I'm here this morning to do my very best to persuade you that the gentleman, Mr. Oai, is entitled to reversal of his conviction on all 4 indictments and a remand for a new trial. Notwithstanding count 1, where I suggest that even on the law, as I understand it to be prior to the Kahneman, a decision relative to supervising probation officer Branco, that charge should be dismissed for a lack of sufficient evidence for a required finding standing. Overall, the basis of my claim, Judge, is following my client's conviction of 2 counts of threats and 2 counts of intimidation of witnesses, being the probation officers. At the time that the gentleman was tried and convicted relative to threats, and in my opinion, relative to the intimidation of a witness charge, insofar as the operative elements are threaten, intimidate, or harass a probation officer in this case, that none of those elements at the time of trial required the subjective mens rea element that was announced by the U.S. Supreme Court in 2023, the Kahneman versus Colorado opinion.
Wait, so I'm hearing you say right now that this applies not just to the threats, but also to the intimidation?
Yes, Judge. Insofar as...
Did you argue that in your brief?
Yes.
Okay.
Oh, yes, Judge. I went through 1, threats. My sub-footnote 2 was intimidation. And then 3 was how Kahneman applied to both buckets of indictments, and then my sub-4 in my merits argument was why there was prejudice for not instructing the juror consistent with the Kahneman opinion.
Could I ask a question on that point?
Yes.
With respect to the intimidation charge, can you explain to me the circumstances in which a defendant could be convicted of intimidation under the existing statute and instructions that were given in this case, and not have the mens rea required in counterman when it was a to punish theory for the intimidation?
Absolutely. So intimidation of a witness is instructed to the jury, whoever willfully, directly, or indirectly communicates a threat, intimidation, or harassment. The willful, be it direct or indirect, is, in my case, picking up the telephone, the intention to communicate. You willfully communicated. What the communication is, whether it is a threat, intimidation, or harassment, under the settled law at the time, that was an objective standard. Whether or not Mr. Borden or Mr. Branco, in light of their relationship with my client and knowledge of them, whether or not they could whether person with that knowledge could reasonably understand that they were being threatened, that they were being intimidated. For example, Cohen 1, relative to intimidation, the subjective intent of the speaker is irrelevant as it pertains to intimidation. This is all a reasonableness standard. How would the recipient receive it? The specific intent is to punish or retaliate as a jury found for participating in that hearing. So a jury instructed at the time would simply, well, not simply, but would have to find beyond a reasonable doubt that Mr. OSTIGUY picked up the phone, made his voicemail message intentionally, that Bronco and Borden perceived it as threatening.
No. With the intent to, or with reckless disregard of the fact that it may punish. With the intent to punish, or with reckless disregard for the fact that it may punish.
That he's making the call with the intent to punish or retaliate.
I'll follow you on the willfully, that the willfully has to do with making the call, but the intent is about what his object of the threat is.
Right. The specific intent is why he made the call. What makes it criminal is that the idea that what he said in the voicemail was considered legally to be a threat, was legally considered to be intimidation, or was legally considered to be harassment. And the only way a jury under now existing law can find that communication is intimidation, is threat, or is harassment, is to consider the subjective intention of Mr. OSTIGUY when he makes the call. Does he have a subjective understanding that what he's saying is or will be received as threatening? So, for example, Mr. OSTIGUY, Mr. Borden participated in the hearing. Borden, I'm going to wring your neck the way you treated me. Well, did he intend to threaten? Did he intend to intimidate? Or is he frustrated, right? It's now under counterman, there has to be a jury instruction. You must consider whether or not the defendant subjectively intended to threaten, intimidate, or harass, or whether he was sufficiently aware enough that his statement could be received as threatening intimidation.
Why doesn't the to punish make get you over the rail on that? Why isn't the requirement where the jury found that the intent of the threat was to punish Borden or Branco, then why doesn't that cover that ground?
The intent to punish is the reason for making the call. I am calling and I am saying these things to you because I don't like what happened in the court. We're allowed to express our dissatisfaction to each other about what happened in court, whether or not it's a probation officer, a judge, or the like. What makes it criminal under counterman is that what is communicated, it meets the First Amendment definition of a punishable threat. And it's not just that, with respect, it's not just that Borden and Branco took it that way, but it has to be, respectfully, that there's proof that Mr. OSTIGUY intended it to be received that way, or he was aware enough of the surroundings and his relationship with Mr. Branco and Mr. Borden that it would be received that way. So he can intentionally say something to Borden and Branco to punish, I don't like what happened, and these are the things I'm saying to you about what happened. That all fits intimidation and threatening if the jury finds beyond a reasonable doubt that Branco and Borden were reasonably apprehensive that, it was a threat of force or the like. But under counterman, there has to be, in my opinion, a mens rea requirement that the jury has to be instructed, and they must find beyond a reasonable doubt, picked up the phone intentionally, spoke words intentionally, and that what he spoke he wanted to be threatening, or he consciously disregarded the likelihood that it would be received as threatening. And the reason why he called was because he was upset and disgruntled with what happened in the district court hearing. That's where I'm coming from. I know there's a lot of intent in this statute, and when we're talking about speech and First Amendment, I think it shows just how precise the charge and the evidence has to be so that it does not fall, so that a gentleman or anyone is not punished for expressing, even if it is a true threat. Counterman says that we don't like him, but you must prove to make it criminally liable beyond a reasonable doubt that he intended to threaten or that he disregarded the likelihood that it would be received as threatening. So there's two intents in that statute, no getting around it. You intended to make the call or the communication, and you intended to say what you said to punish. But what you said is what makes it criminal. Is it a threat? Is it intimidation? Is it harassment? Under current law, if a reasonable person in the position would say so, then it is so. As it stands now, there must be proof that the defendant said what he said, intending to threaten.
Can I interrupt you again with and I apologize for if I am interrupting you, but is the theory of this case was not focused on whether the words spoken were a threat as much as they were focused on the mental defect issue and your client's ability or inability to restrain himself from saying the things that inappropriate, I think is the word that was used in the transcript, from saying inappropriate things. Am I understanding that correctly?
Yes, I follow that, Judge. I don't think there was much contest that under a reasonable person standard suggesting biological warfare, flash and boom to the supervising probation officer, and I can make you unemployed and you notice I didn't make an insufficiency of an evidence on threats and intimidation under existing law. And the defense, and this is why I think there's prejudice in this case, and this is why I think there's absolute importance in this case, is the defense was exactly that both doctors, Commonwealth and defense doctors, agreed that my client suffered traumatic brain injuries from a number of historical events in his life. And I think they both agreed, or at least the defendant's doctor testified that he has impulsivity control. And what's really important about my case is defense expert, defense witness, put in evidence that Mr. OSTIGUY didn't necessarily understand that his statements would be received as threatening. I believe there's a quote.
One sentence, right? One sentence on that at the end of the testimony?
But with respect, mind you, that he's clairvoyance, right? The defense attorney is playing the case that he has. It would be, in my opinion, it would be almost, not frivolous, but it would be difficult to use his mental health to say, and he didn't intend to threat, when the whole case law, whether it's Supreme Court, SJC, the jury instruction itself, is not to focus on at the time, was not to focus on the subjective intent. But even in that landscape, the doctor said, he gave this testimony that he doesn't understand, that he says things without understanding how they will be received. That's precisely what Counterman says you have to,
But didn't the jury reject that? Didn't the jury's guilty finding mean they found beyond a reasonable doubt that he did understand the wrongfulness of his acts?
Sure, but again, NGI is an affirmative defense. It presupposes that the Commonwealth has proven beyond a reasonable doubt that OSTIGUY communicated directly to the two probation officers, and that a reasonable person would understand that these were threatening or intimidating or harassing. So it says that finding says that Mr. OSTIGUY knows it's wrong to make inappropriate comments, or he knows it's wrong to call and say things that will be received that way. But that NGI finding doesn't remove the burden on the Commonwealth to prove the essential elements of the charge beyond a reasonable doubt. So saying that they found that he could substantially comport himself to the requirements of law insofar as he said something that a reasonable person could interpret as a threat, right. But now, under Counterman with respect, that jury finding doesn't mean that he said those words with the intent to threaten them and he knew that was wrong. It just says that he made the words and reasonable people would agree, and his NGI doesn't excuse his behavior. That wasn't a defense to the mens rea subjective element that Counterman announced just last year, Judge.
Yeah. So at the beginning, I was not clear on that you were making the Counterman argument on the intimidation, because I read your brief as focusing on just Branco. And could you address why the proof is insufficient as to Branco?
On the required regarding Branco, the law as it existed at the time,
right.
Intimidation of witness, I rely almost on the Wheeler case to rather extensively, because relative to Branco, he's the supervising probation officer. Mr. Borden is OSTIGUY's probation officer. Mr. Borden was involved in the hearing in the district court regarding custody of the dog. Mr. Borden was the one who participated in that hearing, who was called in by the court, who Mr. OSTIGUY had words with at the district court hearing, etc. Mr. Branco hadn't, according to the testimony, supervised Mr. OSTIGUY in years. He knew him, but he had no knowledge that there was going to be a court hearing in the district court on that day that it happened. He was in his office. He was supervising and managing the probation department. He had no involvement in the hearing. He had no involvement in bringing it about, calling it together.
So why would your client call him specifically and threaten him?
He knew him.
I mean, your client must have thought he had something to do with the hearing.
Well, that's, with respect, I suggest that's speculation that isn't supported by any aspect of element in the transcript.
Isn't that an inference rather than speculation?
I don't think it's a fair and reasonable inference. I mean, he clearly called him, no doubt about it, and at the time, it was a threatening call. But in terms of...
I didn't mean to distract you from...
but in terms of the elements of intimidation of a witness, at the time, he made a threatening call. But to say that threatening call was to retaliate against him or to punish Mr. Bronco for he never participated in it. So, you know, I don't mean to suggest that the court is speculating. I mean just in terms of analysis of the record in fair and reasonable inferences.
You know, I say that because that's how the case differs from Wheeler. In Wheeler, the case specialist wasn't even being threatened. The threat was being conveyed through this case specialist to the judge. And here, the person who you say stands in the shoes of the case specialist actually was threatened personally.
Respectfully, I don't believe that Wheeler turned on what the direction of the. So, I understand that in Wheeler, as raised by the Commonwealth and brought up by the court, that the case specialist then conveyed it to the judge who presided over the harassment order hearing. But the ruling in Wheeler turned on the idea that the case specialist had not participated in that harassment hearing. That is precisely why, as I read Wheeler, the required finding was entered in that case. So I agree that this is slightly different insofar as OSTIGUY directed communication to Bronco. He did. But still, in terms of essential elements, it's found by the jury that it was for retaliation for participating in. I mean, that's an essential element of the offense that he was tried, convicted of. There was no evidence that Bronco participated in the very hearing that my client was convicted of saying these words to punish him for participating in a hearing that he didn't participate in. There's simply no evidence. Why he called, it's not developed in the record. I don't think it's fair with respect to try to infer why he did, because there's nothing in there that would support an inference.
I want to ask you
Yes, Judge.
one more question. So you saw Mr. Nato's letter to us yesterday. You saw the letter alerting us to the SJC's case that addresses, well, not intimidation, but the threats. Should we stay our decision here and to wait for the SJC?
Probably. I mean, they are addressing threats in the mens rea element in a large part. We didn't discuss it. I wrote it in my brief about there are a number of what I feel are evidentiary issues that were prejudicial to my client that I think the court could address. Like, for example, if it were the court.
No, I see what you're saying. We could rule in your favor without addressing councilmen. Is what you're saying.
Right. You don't have to get into the First Amendment if you agree with me that these gentlemen vouched. They talked about, oh, this was.
I got you. I got you.
Okay. And Judge, regarding my brief, I wrote the intimidation argument in my brief. I don't want to be stuck with waiver. I can pull the pages out and show you. I really did my best on the fact that
maybe I was not attentive enough.
And if it weren't for Guardado 2, I would have asked for reversal on everything. But as I saw Guardado 2, once the Supreme Court announces a new element, I'm not stuck. But I have to request a new trial as opposed to a required finding.
Right. That's
why I did.
Okay. Thank you. We'll hear. Do you have another question? Sorry.
Yeah. Does your argument rely on your particular client's condition, his defense? For instance, let's say a hypothetical, there is a defendant who doesn't have such a defense, didn't offer such a defense. Under the reckless standard, would that be enough? Would the Commonwealth's evidence be enough to establish that the defendant was aware of the intent of these statements?
So my response is as follows, Judge. Irrespective of the mental condition of the defendant before the bar, under counterment, the essential elements now of threats are directed a communication, injury to another or property to another, that under the circumstances one could reasonably believe he has the ability and will do it, and that he did it with the subjective understanding that he intended to threaten or that he recklessly disregarded the idea. That's irrespective of what the gentleman's mental state is. That's just an essential element that has to be proven. What I suggest makes my case a little bit stronger is that Mr. OSTIGUY presented and the Commonwealth did as well, evidence of this gentleman's mental state. They relied on NGI insofar as threats as intimidation was general intent. That's the best you can do. But even in those circumstances, my client did have expert testimony that he says words without understanding their meaning, which I think just calls out for the prejudice of this case above and beyond what I suggest is required even under just the idea that no matter what the charge, if they're the essential elements, the prosecution has to meet them beyond a reasonable doubt.
Thank you.
Okay.
Thank you.
We'll hear from the Commonwealth.
Good morning. May it please the court, Stephen Nato on behalf of the Commonwealth. I'd like to begin with what I think is a crucial distinction with counterman as applied to both offenses in this case, although I'll focus primarily on the intimidation charges because obviously the SJC will ultimately weigh in or is weighing in on the threat statute specifically. But the counterman statute dealt with the act of communication itself with no reference to what was communicated, only how it was taken by the recipient. In that case, of course, that was a stalking statute that dealt with sort of multiple kinds of conduct that could give rise to the conviction, but in that particular case, it was only his communications that led to the conviction. And where there was no reference to either the content or his subjective intent about the content, it was violative of the First Amendment. Just to lead into intimidation, touching briefly on threats, here, contrast, there has to be, the communication has to be an expression of an intent to harm the person or property of another, intentionally communicate to that person, and in circumstances that would justify essentially their taking it as a threat. And then you go one step further, in this case, to the intimidation count. The expression of that threat has to be specifically intended to retaliate, harm, punish someone for their involvement in a criminal proceeding. So, where one of the chief concerns in counterman is the potential chilling effect that a criminalizing conduct where the defendant does not have a sort of subjective intent, I would suggest, as to both threats and intimidation in the Commonwealth, that's less of a concern because it is not punishing the act of communication itself. It is the expression of the threat, the intent to harm the person or property of another. Pardon me. So I think those are two clear that's the clearest distinction where there is specific intent to sort of touch on what Justice Hand asked about. Someone, in this case the defendant, who is, again, the content specifically threatening biological warfare, referencing his counterterrorism training, the possibility that the courthouse may not be there in the wake of his displeasure with how this hearing went. There's no way he could have made those comments specifically intending to retaliate or intimidate against these probation officers in a expressive way that's protected by the First Amendment. He has a improper intent specifically found by the jury in this case, and so I just don't think the First Amendment problem clearly arises under the intimidation statute. Under counterman, I mean, it's, obviously, we always say that you can never, you can never get direct proof of intent. It always has to be through circumstantial evidence, right? I mean, it's very rare that you get direct proof of intent. But is it going too far to say you can infer the intent from the language of the threat? I mean, isn't that sort of what counterman says you can't do? Well, I think as a general matter, and it's sort of a commonly stated that intent is often sort of resorted to by proof of circumstantial evidence based on the circumstances.
Right. I defy any human being to express their intent in a way that's consistent with councilman. But I'm making you this threat with the with reckless disregard for the fact that that it's threatening. I mean, it's. But anyway, it's got to be, it's often going to be inferred, but can we just look at this language and say, and infer intent without something else?
Well, I don't think it's, you necessarily need to look at just the language. I think perhaps the language here is so directly, threatening some sort of cataclysmic harm. The intent seems clear based on the words themselves, but it's not just the word, it's not like he wrote a letter. He had sort of his outburst in the courtroom, given the circumstances of the case, sort of as it played out, given the individual probation officer's specific familiarity with the defendant. Those are all sort of circumstances you can look at in addition to the words themselves, and again, not just the words, but the tone, the manner in which they were delivered. So again, I don't think it's just sort of, if you sort of took a transcript of his statements, that maybe that wouldn't be enough, although again, it's pretty direct threats in these circumstances.
So I want to understand your argument. So as far as intimidation, your argument is that the intent required by countermeasure is included already in the language and in the statute. But you would also have to say that it's not included in the threats statute, right?
Well, I think intimidation is clearly sort of outside the countermeasure problem based on the specific intent to do the wrongful act and have the wrongful consequences of that act. Threats, again, poses a closer question, but is not, again, the same countermeasure problem because it's not just the knowing act of a communication that's communicated to someone. It is the expression of intent to harm intentionally communicated. So that sort of, deals, in countermeasure, he did not have to express anything in particular.
Is expression of intent the same thing as intend?
Not exactly, I would say. Right. So that has a problem, but again, soon to be weighed in upon. But as to, again, that distinction, to go back to your question earlier about the stay, even granting that there may be a problem, generally speaking, with threats as it's prosecuted in the Commonwealth, I think a stay is not necessary in this case because the court need not reach the threats point on its own. It can decide clearly that intimidation is not, again, does not raise the countermeasure problem. And in these circumstances where essentially the act of intimidation and the act of threats are entirely coextensive, any error as to the threats instruction was harmless beyond a reasonable doubt because the jury had to find beyond a reasonable doubt, again, the criminal mens rea in this case that was specific intent and surpassed recklessness.
They had to find it in the intimidation.
Sorry?
They had to find it to find him guilty of intimidation.
Yes. If there's no further arguments on that point, or questions on that.
I would just ask one further. I mean, the specific intent is the final element or the second element, but not the first element. You don't think that's a distinction? Not a specific intent to threaten, but specific intent that the threat or the harassment or the intimidation was specifically intended to harm or not to, harm, punish, or retaliate. So my question is, the specific intent seems more specific to the second element, not the first, and you don't think that's an issue?
Sure, but I think in the circumstances where, and again, I raise what is the chilling effect or what could be the legitimate First Amendment purpose for communicating a threat with the specific intent to essentially violate to intimidate or retaliate against someone for their participation. It's sort of more of a conduct based thing than and his intent to engage in that conduct rather than the the speech itself. But again, I think where they are coterminous in this case, and in all circumstances, it's not really vague or ambiguous. He's pretty directly making these threats to guys that he knows are sort of familiar with him. And so in all those circumstances, I think even under the threats, where that may potentially, depending again on how the SJC rules in this particular case, any error there is harmless. Turning from that point to the question of whether Mr. Branco was properly served as the basis of a conviction in this case, again, I disagree with my brother. I think Wheeler is clearly distinguishable. There, the case specialist essentially functioned as an intermediary of a threat that, by no terms was directed at her. It was clearly directed at the judge, and no indication that that specialist had any particular involvement in the proceeding itself. And here, while Mr. Branco was not granted involved in the hearing itself, the proceeding as it was, what the defendant was upset about was his conditions of pretrial release that had resulted in his dog being taken from him. And so the call to Mr. Branco was specifically intended to him based on the conditions of probation overseen by the department of which Mr. Branco had a managerial and supervisory role.
So if we agree with you that Wheeler is distinguishable and are looking for what evidence we can rely on to say that there was a reasonable inference from the defendant's point of view that Mr. Branco was involved in this proceeding, what would you point to?
I think you can look at the sort of the very kind of quick timeline with this is pretty apparent, or I don't know exactly who he called first, but certainly currently blanking on his name, but the probation officer involved in the hearing heard the voicemail first, and then in short order informed Mr. Branco, who then also had a voicemail apparently left within the same sort of couple hours, perhaps in the wake of that hearing. Clearly still mad about the hearing itself, the conditions of probation, knows that Mr. Branco is involved as the assistant chief, has some personal familiarity with him. So I think those circumstances, and again, his,
and we get that
directly, Dave,
We get that from Branco's testimony?
Yes. I think both of their testimony, they sort of kind of put that together, but certainly primarily on Branco's testimony.
If we put aside assuming that supervision of Mr. Branco's supervision of Mr. Borden didn't directly involve Mr. Branco in the proceedings that Mr. Borden was involved in, does it matter whether, and we infer that the defendant believed that Mr. Branco was somehow involved, does the accuracy of the defendant's belief matter? Does he have to be correct?
Well, I think the person under the statute does have to, so if, Mr. Branco wasn't working for the probation department and the defendant mistakenly, or like he left, and he perhaps believed he still did, he's not a probation officer involved in the proceeding.
Okay.
But again, Mr. Branco's official role was the assistant chief that was overseeing those conditions, and that is specifically why the defendant made that call. It wasn't just Dave, we go way back, can you believe what they're doing to me in court? It was, he was mad about the hearing, was directing his fury and his threats at Mr. Branco specifically for that reason. I see I'm sort of running low on time. If there are any other questions on that argument or the third one, if not, I will rest on the brief.
I just want to thank you for calling our attention to the Cruz case, and for both of you. We took a look at the briefing in the Cruz case, and the briefing in this case is a lot better. So, really well done by both of you, and really interesting case, and it's submitted. Okay, the second case we have on for today is Commonwealth versus Emanuel Bay, 23P 630. Well done there. I've so many times I've had the experience of spilling, so.
And I think that very thing happened to me last time, so I'm a pro now. Good morning, Your Honors. My name is Hayne Barnwell, and I represent Emanuel Bay on this appeal. This case is about Mr. Bay being unconstitutionally deprived of a sword and a shield. By violating its Brady and discovery obligations, the Commonwealth concealed from him the sword of impeachment in the form of a lawsuit TM was pursuing in relation to this case. By failing to provide effective assistance of counsel, his trial attorney deprived him of the shield of suppression. And as a result, Mr. Bay was subjected to over 100 text messages and other phone data, well serving the Commonwealth's goal of portraying Mr. Bay as a man who was, quote, on the prowl at UMass, as one of his text states, a man who coordinated with the other three men to rape TM and worked with them afterward to cover up the crime. Mr. Bay appearing for trial without this sword or shield in an aggravated rape case proves that justice was not done. Turning first, unless the court wishes me to start elsewhere, the Gallarelli standard for prejudice and how the motion judge's motive analysis in this case was fatally flawed.
Just to set this up,
Yes.
a question. Am I understanding correctly that your client joined in Mr. Liccardi's discovery motions, it didn't file separate ones, but was following the same argument? Is that correct?
Yes, he joined in all of the discovery motions.
Okay.
And were they,
yes.
and were they both at the present for the same hearing on, okay.
Yes, and eventually, as the court likely knows, I think around March 2015, they were finally severed for different trials, and Mr. Bay's trial went first.
But there was in Liccardi's, he actually got an appeal in the middle of the motion for new trial too, right? Like he had an additional appeal where the court remanded it to the trial court for a hearing on the.
Oh, yes, I'm sorry. So I was thinking of
No.
an interlocutory appeal.
That's,
you mean post-conviction? Yes, Your Honor. So his, I'm going to try to get the chronology right. His motion for new trial went first before Mr. Bay's motion for new trial was filed. That's correct. And then the argument in that motion for new trial, or at least the bone of contention, was, is this a general request, the presentment letter, or a specific request? And then the panel concluded this was a specific request because they asked for any and all communications about a potential lawsuit, and a presentment letter as part of the potential lawsuit. So then it was remanded back to the motion judge to determine whether the standard for prejudice, at that point now it's the lowest standard of prejudice other than structural error, whether that had been met, and then he stated, concluded, no, I've come to the same conclusion, and then here we are with the new evidence that actually the prosecutor did know that they were going to file a presentment, et cetera. But as far as the Gallarelli standard, Your Honors, the theme of the motion judge's errors, and in this case, the motion judge was not the trial judge, so he's not owed special deference.
But he did hold a separate hearing with respect to the prosecutor's, your client's arguments about prosecutorial misconduct, and made findings of fact and assessments of credibility in connection with that portion of the motion for new trial, correct?
Correct,
So
yes.
we do defer to that portion of the fact finding and the credibility assessments, don't we?
You defer absent clear error, but he did make a number of errors that I'll go through, and I'll try to focus more, of course, on the legal errors. But what do you see in his decision? The theme of his errors show that he's supplanting his own opinion about this evidence for that of the jury. And the case law is clear that the jury is the reagent. And if you go through his reasoning really what he's saying is only what came out of trial matters. It's not what we learn later about the Commonwealth finally disclosing this impeachment evidence. So, for example, he states in his opinion, well, basically with TM, in cross-examining TM, you had defense counsel that $500 demand. And so I'm just going to sort of limit myself to that and dismiss everything else. Instead of integrating into that, well, what could we have done with that $500 demand if trial counsel had known about this huge lawsuit that she was pursuing, upward of $100,000, damages, perhaps more? That's an entirely different universe than $500. And how does that color the rest of her testimony to the jury? In other words, imagine it comes out the same way as she testified. That $500 demand, that wasn't about money. That's not about cashing in on a serious accusation. That's about keeping them away from me. I didn't want BILE or any of them anywhere near me, so I'm trying to scare them away from me. Now, with this information, trial attorney could have said, okay, you say it's not about cashing in on a serious accusation, but then you file this huge lawsuit. So it is about cashing in on a serious accusation. Now, how she responds to that, how the jury will look at that, that is uncertain. I think the parties would agree. We don't know exactly what she would say, and we don't know exactly what the jury would do with that. But given that this is the lowest standard of prejudice, that reversal is presumed unless this court can be sure that it would have no effect or very slight effect, this would have at least had some effect upon any rational jury, considering the credibility, which was key in this case, of TM and BILE, who also testified. And then the other...
So I mean, the jury then, wouldn't they have to, they'd have to believe, okay, not only did she make up the lies really quickly to seek the $500, but actually she had this whole plan that 2 years later she was going to actually sue the Commonwealth on this. And she also knew about victim compensation. She was going to get that too. Isn't that kind of a reach?
No, no, because we don't know exactly when she hired Attorney Chico to pursue this lawsuit. That's one of those uncertainties that the court has to consider. And Elliott, the SJC, found that very persuasive, that, we don't know exactly when she contemplated this civil suit. We don't know when she hired the attorney. But what we do know is that we don't know, and therefore it should be left to the jury to ferret all that out. And also, it matters when she's under oath. It's one thing to tell your friend vaguely, I was gang-banged, they raped me, and then talking to the police. It's quite another to be under oath. And as the trial attorney in this case, Attorney Pixley, testified to in the evidentiary hearing, and that was not discredited at all by the motion judge, he had several inconsistencies that he was working with from the time that she spoke with the police and the time she testifies at trial. And the significant inconsistency that he pointed to was when she spoke with the police, and I don't believe her statement came in at trial to the police officer. It was recorded. However, I believe the transcript of that is in the impounded appendix. And so what he said was, what I could have done was, when she talked to police, she said only when the attack began, it was kind of dark, but there were only 3 there, 3 men, 3 out of the 4. BILE was not in the room. But when she gets to trial, all of a sudden, they're all attacking her, they're all raping her, and it's all happening like all at once. And again, Commonwealth had to prove not just rape in this case, but aggravated rape. And their theory about aggravated rape was this was a joint venture. And so that was very critical at trial. And the other legal error that he makes in his decision is he's moving the goalpost, if you'll notice, throughout the decision. Because when the issue is about prejudice, the motion judge claims, or he states, well, it only matters what her motive was in October 2012, sort of similar to what Your Honor was suggesting there. But when it's about whether the prosecutor committed misconduct, well, now it only matters what her motive was at the time of trial. And so you see that sort of shifting of the goalposts. It shows that, again, he is tying himself in knots to try to keep this in his view, in his judgment, what the evidence means to him, and not what a rational jury would think of this when we have this huge lawsuit along with everything else that may explain how her story and why her story evolves, and that would have been critical for the jury to know. And I know another part of his decision, he says, well, TM wasn't really the linchpin of the case. It was Jessica Russo and Carissa Youngs, who were her friends and her floor mates. That also just doesn't hold water. Of course, TM was an important witness in this case. She is the complainant. She was the only one in the room when the alleged attack began. And her testimony completely contradicts her floor mates. Her floor mates are like, she was so intoxicated that she was passed out and all this. And instead, TM testified, no, I was awake, I was conscious. Yes, I was sort of sitting on the bed and hanging out. I was drinking, I was intoxicated. I was sort of leaning on the bed, but she never said, I passed out, I slept. In fact, she says, I was standing, I was awake, I was conscious. And when the attack began, I was standing up. And then once they started attacking me, I fell on the bed. So TM was clearly important in this case. And we can argue about whether she was the key witness or not, but she was obviously still very important, a key. I think how the SJC put it was, it doesn't matter to us whether it's a key. I apologize, I can't remember the case name, but it's in my reply brief. It doesn't matter to us whether you call this witness a key witness or not. It's whether this witness provides an important chain in the link of evidence, and of course this witness did.
Counsel, the defendant's confession or admission is very strong evidence, I would suggest. It's recognized generally, a defendant's confession is observed by the jury as strong evidence. And here, the pretty strong statements of guilt. How would you address that in your analysis of whether or not this presentment issue may have influenced the jury?
He never confessed, Your Honor. He has maintained from the beginning that this was, in his view, consensual. They did not force anything on her. Now, he was proud, when they were giving,
Didn't he say she said stop twice?
I'm sorry?
And she was crying? Didn't he say she said stop twice and she was crying?
That was after he was no longer having sex with her at that point. That was after, this is the statement, by the way, the testimony, a bit different, but if we're just focused on the statement, he tells the police that Justin King at that point was having sex with her. He stops, he starts putting on his clothes. That's when she starts crying. That's when she starts saying, stop, stop. So in other words, everything had already, all of that had been done before that. But we also, of course, don't know, because we don't have access to the deliberations, whether they even considered that statement, because they did get the humane practice instruction. So we don't actually know whether they weighed that at all. If I could just talk briefly about suppression, because there was a delay, a 40-day delay in getting this search warrant. And that not only was a viable motion to suppress, that was dispositive. I mean, that would have obviously been successful. The Commonwealth doesn't really have any good response to that. The law is that you have to be diligent in getting the warrant. It's not about diligent generally in the duties. It's about diligence in actually getting the warrant, and the Commonwealth has never offered anything to suggest that they were diligent. Commonwealth versus White, and I believe the case that I've sent in as a 16L, the Cedric Williams, which is an unpublished case, but I think it also persuasively lays out, that it's not about how difficult the investigation is, or that, that you're trying your best as an investigator to handle all these balls in the air. It's about whether you actually made it a priority to get this warrant, and clearly here they just didn't. And as far as the supposed complexity about drafting a search warrant, I frankly just don't even understand that. Cell phones, I'm pretty old, but I'm pretty sure that cell phones have been ubiquitous since 2012. And it wasn't a mystery about how to write a search warrant, to get texts, to get calls, to get data. The extraction process that the motion judge refers to, that comes after. you don't have to detail in your search warrant about like how Cellbrite works, right? You just have to ask the judge, this is what I want to get from it, however I get it. And as far as prejudice on suppression, if this court agrees that the evidence from his phone should have been suppressed, this was a centerpiece. These texts were a centerpiece of the Commonwealth's case, opening, closing, and I was frankly impressed. I read again the prosecutor's cross-examination of Mr. Bile, and she deftly maneuvered, saying over and over again, so you coordinated with them, and then you hear these texts where you're coordinating with them before, during, after, and she details every single word that they said in some of these texts. And then all of that.
Isn't another one of the factors in the delay cases the importance of the evidence to the Commonwealth case?
I'm sorry?
Wasn't one of the factors in the delay cases besides diligence the importance of the evidence in the Commonwealth's case? I mean, the Commonwealth cites the Arthur case where there's an 85-day delay, and they basically say this was just so important, and it was going to be used as evidence anyway, that the delay was sort of immaterial.
No, my recollection of that case was that they had a really good reason for that delay in those specifics, that they were also getting warrants and such for like the co-defend. It was a very complex. They were being diligent as possible in getting the warrant in that case. And I apologize, I can't remember exactly the details in Arthur. Okay. But it wasn't like that the standard was jettisoned. I mean, Commonwealth versus White is the law. You got to make it a priority to get the warrant. And Arthur certainly doesn't disturb that law. Okay. If there are no further questions, thank you, Your Honors.
Good morning, Your Honors. May it please the Court, Bethany Lynch, representing the Commonwealth. Unless the Court directs otherwise, I will follow the same path that my sister took, and I'll discuss the prejudice of the discovery issue first, and then move on to the suppression issue. The motion judge in this case was not the trial judge, but he did hold an evidentiary hearing on this exact issue and fully credited the trial prosecutor, who's Deputy D.A. Sewell. And D.A. Sewell, he found that there was no egregious misconduct. I know we didn't really talk about that, but there was no egregious misconduct. There was no deliberate withholding. That standard was not met in this case. For the presentment letter, I think it's very clear from the hearing that DDA Sewell never had the presentment letter, and her understanding was that when the lawsuit was filed, or she had information that it was about to be filed, at that point she would let the defendants know. And in this case, I think it's important to note that the lawsuit in this case was not filed until after the convictions and pleas, until the disposition of all of these cases. It was filed, I believe, in October of 2015 at the completion of I believe it was Mr. Liccardi's case was the last trial. And so at that point, the lawsuit actually happened. So prior to that, while it may have still been contemplated, and while we do not deny that a presentment letter had been sent.
But so if the defense counsel had known about it during the trial, that you had filed, you're actually intending to file a lawsuit after this trial, aren't you? I mean, isn't that pretty?
Absolutely. No, he absolutely could have impeached her with that. I would suggest that the impeachment value of that, which is what the motion judge's findings basically come down to, is that the impeachment value of that, in light of this particular case, would have been minimal. So the Commonwealth has always acknowledged that had we had the presentment letter, had the district attorney's office had the presentment letter, DDA Sewell would have turned it over. The UMass Police was served with a copy, which it was not required by statute either. So there was no real indication that we would have received a copy of the presentment letter as our agent. But we did not receive a copy, have always acknowledged from the beginning of litigation in Liccardi on this case, when the presentment letter came forward, that we would have turned it over. But we've also maintained that the value of its only value is for impeachment, and that the impeachment value of the presentment letter would have been minimal. The victim in this case was an 18-year-old college freshman. She'd been in college for a matter of weeks at the time of this incident. And as Your Honor noted earlier, in order for it to be persuasive impeachment evidence, the victim would have had to have planned this out long in advance, including understanding that suing a public institution for failure to secure the dormitory to which she was assigned her residence hall, all of that would have had to have been known in order for her to know what to say to the police to plant the evidence necessary to support the search, to support the lawsuit later. So I think that that is the thought process that the motion judge had in this case. And I will say that the motion judge in this case, while not the trial judge in Mr. Bile's case, was the trial judge in the Liccardi case, and that was a lot of the same evidence and saw the same witnesses. So he was very, very familiar with the case. He wasn't a motion judge who just came in and picked it up and may not have understood some of the nuances. He was very familiar with this case. The same applies with the VCAD records. You know, the prosecutor in this case at the time, it was pre-Torres, it was 4 years pre-Torres, and the victim compensation records were not something that the DA's office had, or that we would have thought that there was a mechanism for us to even get if we were so inclined. Prior to Torres, there really wasn't a mechanism for anyone. They're confidential records. There was no mechanism. And Torres, the mechanism in Torres is Rule 17 by the defendant. So while the prosecutor's offices now, the DA's offices now turn over, at least our office, turns over if we have an application, an actual application. We have a physical, we know she has filed an application and here it is and here's the information. That we now provide in discovery as a matter of course, post-Torres. Pre-Torres, we did not, because the understanding was that that wasn't an obviously exculpatory piece of evidence. Just the knowledge that she was filing an application for reimbursement through the Victims' Compensation Fund. So I think the general theme in all of these, the presentment letter, the VCAD, all of that, they're all impeachment type evidence. And while the defendant and my sister may argue that the victim TM in this case is the crux, she's the most important witness, she is the key witness in this case, and her credibility was all. Without her credibility, the defendant would never have been convicted. They're free to argue that. I vociferously argue with the opposite, that while she was the victim in the case, she was incapacitated. She was so intoxicated that she had very little memory of what was going on in terms of any details. And any piece of truly inculpatory information that went to the elements of this case, they were corroborated by other people. They were corroborated by other witnesses who didn't have the weakness of being intoxicated to the point of incapacity at the time of the incident. Her incapacity, I'm not sure that it's fair to argue that she even recognized her own level of incapacity during her testimony in describing what had happened. She would say that she thought she was okay, as I would suggest a lot of drunk people do. But her dorm mates saw her, and they saw her passing out on the bed. They saw her incapable of walking in this small dorm room from her bed to her closet to change her clothing, incapable of helping change out of her clothing and into pajamas for bed, leaning on people for support. Basically, when everyone was thought to have left this room, the dorm mates thought that she was just passed out and unconscious and she was going to just be on her own and sleep it off. So her incapacity is, the testimony as to that is laid at the feet of Ms. Youngs and Ms. Russo. Their testimony establishes that. In terms of the sexual activity, impeaching her as to whether the sexual activity happened was pointless because the defendant himself admits that there was sexual activity. He admits what he engaged in. He admits that this was we just all thought we'd take turns with her. She wasn't really saying anything, but we were just sort of back and forth, who's going to go where, who's going to put what where. And that was the conversation during this thing. She was not participating in that in terms of I want you or you. She wasn't verbalizing anything. In fact, his statement says the only words she said were no. And she said that. And yes, it may have been after the physical acts that Mr. Bile performed on her happened, but it was still during the venture, during what was going on in the case, in the assault on her. And also, so the defendant admits that. He admitted that in his statement to the police that he knew she wasn't in her right mind. He texted with her the following morning. He apologized. He said, I don't know, I should never have let it happen. And the fact that you did have first complaint witnesses, you did have his DNA. So the incident happened. So he had sex with her, and the DNA establishes that, as does his own statement. Then you have the evidence of incapacity from other witnesses, and then her immediate report the next morning to Jessica Russo through first complaint. I would suggest that that evidence, even with the victim's credibility being pretty tarnished, had they had the presentment letter, had they said, isn't it true that the victim compensation fund is reimbursing you for this, or had they had any of that to impeach her with, the judge's finding that would not have made a significant enough difference that we can't be sure that it didn't influence the jury. We can be sure of that because of the evidence in this case, because of how this case went in and what the issues in the case were. The issues were incapacity and the defendant's intoxication. They weren't that the incident was made up out of whole cloth or that she's just lying from start to finish and nothing ever happened, she's just after money. So that would be whether you use the standard for the specifically requested discovery, which Liccardi says the presentment letter was, that the judge found, and again, this court's review is whether that's an abuse of discretion for the judge to find that he was sure that error did not influence the jury or would have had a very slight influence. And in terms of the victim compensation money, that the judge found was not requested, and the Commonwealth did not have any indication that the defendant wanted any information about victim compensation. So that would be the lower, or the, higher level of review where it was not specifically requested, and the defendant would have to show that there was a substantial risk that the jury would have reached a different verdict had they known about the victim compensation. And I would suggest that, as just a slight aside, the cell phone issue about the email from the dad, that's the same sort of thing. There was no request for information about the cell phone circumstances, even though the defendants were aware of it. So in those situations, I would suggest that the defendant here is not able to establish that the motion judge abused his discretion in making the findings that he did as to the limited prejudicial impact that the presentment letter, the victim compensation, the discovery-based issues would not have impacted the trial.
Could I ask if you'd explain a little bit about your perspective on the portion of the motion that alleged argued ineffective assistance of counsel based on the failure to move to suppress the cell phone and specifically the prejudice?
Absolutely. The motion judge did find that there were that overall the motion to suppress the cell phone would have been denied with two minor areas of where he said it would likely have been allowed. And one was the temporal scope of the search warrant, and he found that there were, I believe it's 2 text messages that were from a month or 6 weeks, I would suggest well enough before the search warrant, well enough before the incident on October 2nd. Those 2 text messages, however, the motion judge found would not have made a difference because they weren't really inculpatory. They were a month before, and they were talking about, we're going, it's kind of like, I hate to use the word locker room talk, but it was kind of just like talk between 2 18-year-old boys about they're going to go and try and get lucky at UMass.
How about, you want to address the diligence?
Certainly, absolutely.
And the prejudice?
Absolutely. So the prejudice for that one part, I think, is that it was minor because it was removed in time, and there were more pressing evidence.
I mean, you're not arguing that the more contemporaneous texts were not very damaging.
Oh no, they were damaging. Yes, okay. They were damaging.
So you wouldn't say if counsel had, even if counsel had, even if counsel was ineffective for not filing the motion, it didn't make a difference because those messages were irrelevant. You wouldn't argue that.
I wouldn't argue that they're irrelevant. I would argue that in the weighing of the overwhelming nature of the evidence against him, the defendant wasn't a substantial risk of a miscarriage of justice that the attorney didn't file that it was ineffective, that he was ineffective, and that his I'm losing my train of thought, I'm sorry, that In failing to file the
Would
motion.
would those texts have not made a difference to the jury, or would they have made a difference to the jury?
I will acknowledge that they could have made some difference to the jury. I
There's the prejudice.
there is evidence, again, I think that because of the overwhelming nature, I don't know that they were dispositive in any sort of way. They did, and a lot of the most, I would say, harmful part to my mind is the part where they are discussing how they're going to cover it up afterwards. And there's other evidence of that through the victim's cell phone, because this defendant texted with the victim through her cell phone, which would have been separate, that he was going to pay her and that, don't go to the police, I'm going to pay. So that
So what's the evidence that they acted diligently in
Well,
the 40 days that it took?
I would suggest that 40 days is, especially in light of the Williams case. I understand the Williams case it's a 34-day, but in this case, I think that the difference, you can distinguish the Williams case because here, it was complicated. The judge found that it was complicated. They seized 4 cell phones. That's part of the record. They did seize the cell phones of all of the defendants. So there would have been multiple search warrants. Not that they would have been that different, but they would have been multiples. It was technical. I would suggest it was more technical in 2012 and 2013 than it is now. It was on the newer side of this technology to be able to do that. And also there were multiple agencies involved here, where there were not as my understanding, in Williams. Here, the UMass Police Department was doing the investigation, but they were not the ones who had to do the extraction. It was the Massachusetts State Police who did that. So the Mass State Police officer, trooper, is the one who did the extraction and testified about that. And I think that the coordination of agencies and the complexity of getting the warrant at the time and it being as large and complex as the search warrant was, and the fact that the judge, in looking at that, the judge in this case found that not to be unreasonable. And then in light of the fact that the text messages that were anticipated that they were going to find, that they had probable cause to believe that they would find, were important. They were important in linking the defendants together in the joint venture. And so because of the weight of the potential weight of this evidence to the Commonwealth's case and the importance, as well as the fact that there were multiple agencies, and that the text messages themselves, while very helpful to the Commonwealth's case, I think when you look at the entire case as a whole, I don't think that you can look at them and say that that was dispositive, and had they not been there, we would now not believe that the defendant was involved, or that he was not guilty, or that there wasn't justice in this conviction. If the court has no further questions, I would rest on my brief.
Well, I'm sure we have tons of questions. Boy, again, really complicated case, really well presented by both of you.
Thank you very much.
We'll take it under advisement. I'm about to call the third case, and normally on these days we take a recess after our third case, and today's going to be no exception because, as you can see, we've already had 2 pretty substantive cases. So we'll be hearing one more criminal case, and then we'll be returning for the civil cases. So the next case on the criminal side is 23P199, Commonwealth versus William Hidalgo. Please.
Good morning, Your Honors. May it please the Court, Eduardo Masfer on behalf of the appellant, William Hidalgo. The trial court erred when it denied the defendant's motion in limine to exclude prior bad acts, and specifically prior restraining orders, from being introduced into evidence, which the Commonwealth used as propensity evidence against the defendant at his trial, and further erred by eviscerating the defendant's defense by eliminating our expert from offering crucial testimony that corroborated his case and impeached the alleged victim in the matter. First, with the motion to exclude, the Commonwealth moved to introduce a series of prior bad acts against the defendant. Their claimed motion indicated that they were doing it for non-propensity purposes. And in claiming so, they could not identify any particular exception to the hearsay rule that would permit the introduction of that bad act, besides general nature of the relationship.
But that is a legitimate exception, isn't it?
It can be in some circumstances, Judge. It can be for murder cases. It can be for a lot more serious cases where the Commonwealth needs to establish a motive for why the defendant would act in a particular way as part of their case. But I think what you see nowadays in the district court is that every domestic violence case that's charged, they use this sort of blanket exception to introduce everything that they can. And in this particular case, we weren't talking about a series of incidents that occurred in the months or the days or even a year or two prior
I read
to the
that
incident.
there's not a series, there's one incident, right? I mean, that's the way it came into evidence, one incident came in.
No, what had occurred is that they specifically highlighted one incident, 2012, and then used broad terms to say, and then you got a restraining order in 2012, and you got many other restraining orders after that. And she said yes. So it became this sort of amorphous, we don't know how many restraining orders. In their opening, the Commonwealth called the relationship tumultuous. In their closing, the Commonwealth said that they obtained multiple restraining orders between 2012 and 2017.
Why wasn't that fair to show the relationship where the argument from your client's point of view was that the victim was making this up, this whole incident, up as in part as a means or potentially as a means to obtain an opportunity to stay in the United States she wouldn't otherwise have?
It was a combination, Judge. Yes, that was one of the points of our defense, but also that she was unhappy that the defendant was in a different relationship at this point. Because the incidents that we're talking about, the one incident that was mentioned was from 2012, so it was 5 years earlier, and the restraining orders that the Commonwealth made it sound were continuous and repetitive turned out to be one from 2012 and a few from 2014. So there was a large gap in time.
And you did, by the way, and you were the trial counsel, right?
I was.
You did an excellent job of cross-examining her with those 209As.
But Judge, that's not really an excellent job. That's dealing with the bad ruling that I had. And so when the Commonwealth is able to introduce a broad frame, a broad sort of vague assertion of, and you got multiple restraining orders over this period of time, the only way to combat or attempt to combat really this sort of broad, vague, amorphous assertion where the jurors might think, oh wow, she was getting a restraining order every week or every month or constantly renewing them, was to sort of highlight individual facts. Right? The only way you sort of fight against this broad feeling is to say, look at the facts of the particular situation. And so that's what we ended up having to do here. But we should have never been placed in that position, especially when the issue that we're talking about was one 5-year-old allegation of strangulation, which was the same charge here. But then what we're talking about is the issuance of restraining orders. Commonwealth versus Reddy, I think it's Reddy, not Reedy, it talks about the danger of introducing restraining orders and how it sort of suggests that the court has validated or has an imprimatur of approval of the allegations that are being made. And that's where the Commonwealth chooses to focus by saying multiple restraining orders. And that's, I think, the most damaging part. We had to go in cross-examination each one to say, well, you only took it out initially, then you either didn't show or it wasn't renewed. But every time it gives the impression that something is happening on every one of these occasions, even though we all know that restraining orders will issue, a one-party restraining order will issue pretty readily upon a claimant's assertions. And so this sort of constant raising of that occurred during the Commonwealth's case. The direct examination, again, I know we all get used to maybe bigger cases with longer testimony, but the direct examination was 17 pages. Out of those 17 pages, we spent 5 on prior bad acts and 12 on the incident. That was it. There was no other discussion. And the Commonwealth re-highlighted it both in openings and in closings.
But not as
Why no limiting?
Go ahead.
Why no limiting instruction?
That is an excellent question, Judge. There should have been a limiting instruction. And then I know the Commonwealth points out to the fact that I didn't raise that I should have asked for limiting instruction, and I'll take the note. That is true. I should have done that. But the case law doesn't require me to do so. When an evidentiary rule is made for a limited purpose, as this was not supposed to come in for propensity, it was supposed to come in from a limiting purpose, the court had an obligation to give a limiting instruction, if not in the moment, which is what the case law suggests that they should do, and that's specifically Commonwealth versus Mills, but also at the jury instruction portion. And as Commonwealth versus Mills noted, the defense did not ask for a limiting instruction in that case either, and the court said it's on the obligation of the judge. The Commonwealth tries to assert that somehow I didn't ask for limiting instruction because I didn't want to draw attention to the restraining orders, but as Your Honors have already pointed out, I drew attention to the restraining orders as part of cross-examination. That's a life lesson for me as a lawyer, and I'll always be learning, and I'll learn that one for the future, but that does not mean that a limiting instruction wasn't required, or that the failure to give one didn't prevent my client from getting a fair trial. And specifically here, it's how the cumulative effect of bringing up a prior bad act, talking about restraining orders, and bringing it up at opening, closing, and during direct examination infects this trial with unfairness. It focuses the jurors' attention on a variety of acts that were never proven, with the implication, since restraining orders were granted, that they did in fact occur. And Your Honors can see from the way the Commonwealth questions the alleged victim about it, everyone acts like it did occur. Right, the Commonwealth sort of asks, and there were lots of restraining orders, and they were issued, and then the victim says, yeah, the victim says yes, and has to come up with other explanations. But it was a foregone conclusion that these events occurred, and that the court seemed to agree with them. The second issue that I raise is the issue about our expert. As the court can see, the credibility of the alleged victim was the crucial issue in the case. From our perspective, it was not a strong case against the defendant, but it did have a very strong piece of evidence, and that is the photograph. The photograph that was taken of the alleged victim at the scene after she'd been receiving medical treatment, so she had that brace around her neck, I think was a very powerful piece of evidence. And I think on a first blush, you would say corroborates the alleged victim's claim of the attack that she claims she suffered. And our primary focus, our way of defeating that or demonstrating that that was not true, were the medical records that the Commonwealth sought and introduced. And the medical records use terminology that is not always familiar with every layperson who reviews it. And the defendant, as the court can see, his family was able to scrap together the money toward the trial to hire a registered nurse to examine those records and to explain them to the jury. The registered nurse was also going to do one additional thing, which is talk about the common, not symptoms, but common observations that are made of people who claim to be assaulted in some way, shape, or form.
Could I ask this? Even assuming that you're accepting your argument that your witness should have been permitted to testify to the common manifestations of someone who's been strangled. If I'm understanding the voir dire testimony correctly, the answer was essentially, it depends. There's a universe of potential manifestations,
Yes.
some of which, it appears undisputed, appear in the medical records for the victim. Is that correct?
Anyone where you don't have an observation, but you record what somebody says, those are there. So she complains of pain, she complains of soreness, so that is in the medical records. But in terms of redness, bruising, marks, something that would indicate...
ligature on her neck?
I'm sorry?
Ligature marks on her neck?
The ligature marks also could have been from the brace that was placed on her.
Is that anywhere in the record?
It is not, because the judge refused to let her...
But the voir dire, is there any inquiry about that at the voir dire that would indicate that that was what Nurse Kennedy was going to testify to?
Judge, I apologize. I don't recall if that specific question about the ligatures was asked of her, but she was going to talk about what one often sees, depending on, and I think she did testify to this, the strength of the injuries. In other words, there's a difference between a slap or a punch or a hit. That type of contact will not always create the same amount of visible manifestation of an injury. I think she would fairly testify to that. But we had evidence in this case that at different points, the alleged victim had said, I was punched, I was hit, I was strangled and I couldn't breathe, I was strangled and I lost consciousness. And those types of degree of severity of force, I would submit Ms. Kennedy would have testified that she often sees redness or more pressure or finger marks or bruising or something of that nature.
As far as the punching and hitting goes, is that really something that expert testimony is required for? Does the jury require the assistance of an expert to understand that the greater the impact, potentially the more visible damage might be done?
I think it depends on the type of injury, but in this particular case, I was not permitted to argue that point. And I'll point the court to closing argument pages 102 to 105, I believe, where I started to go down this line and I was objected to and it was sustained. And so what happens is I ask, ladies, I think I told the jurors, you can look at Ms. Kennedy's testimony and it does not corroborate or doesn't support what she's saying. I get objected to, it's sustained.
Right.
Then I say, well, you can use your common sense because your common sense would tell you that given what she described, you don't see that in the medical records. That was objected to, that was sustained, and the curative instruction the judge gave in the moment was you can only look at Ms. Kennedy's testimony for medical terms, explanations, and nothing else. And I think maybe like the next page or so, I then go back to that, what I think is a different way of re-raising the issue, and again I'm objected to, and again the judge sustains it. So any attempt or any view, as the Commonwealth suggests, that the information I did get in through her direct examination could have been used by the juror to make these, what could be a common sense inference, I was not allowed to do, and the judge specifically told the jury that they couldn't do that. So I was deprived of that opportunity. So I think depending on the nature of the injury, Your Honor says a punch to the face. I agree, I think a lot of common sense would tell you that a punch to the face would do that. But whether or not strangulation that results in loss in consciousness would have the same type of marks that were not seen on her neck, I would submit that is a different issue, and it's not simply an A and B assault and battery case, there's a charge of strangulation. And so really what occurred here is that, what occurred here from our perspective is that the court's limitations dramatically affected the type of defense that we were able to introduce. I think the analogy that I've come up with, especially post-Olympics, is that if you think of a series of sprinters getting ready for a race, and someone comes over and takes a bat to one of their knees, the fact that that sprinter is able to complete the race, or maybe that sprinter was able to beat one or two people, doesn't mean the race was fair. And that's the issue here. We might have been able to bring up some points, again, working with the court's rulings that I had to, but it was not a fair trial for Mr. Hidalgo, because this issue about whether or not what she claims occurs, and that one, as I've said, very powerful photo seems to demonstrate, and whether that is corroborated by the medical record, something independent and objective, is a major part of the defense and was the heart of what we were trying to do, and that was on some level, on a big level, we had the rug pulled out from under us during the trial. I'd also point out, as Your Honor talks about common sense sort of references, during the Commonwealth's closing, the Commonwealth tells the jurors, and I objected to it and it was overruled, the Commonwealth makes a statement along the lines of, when you can see in the medical records that there's bruising, and we know when there's bruising, something happened, right? So now we're using a common sense to say something about bruising, and a bruise doesn't necessarily mark a time of when it occurs. And now the Commonwealth is saying, without expert testimony, use your common sense to infer something that I was not allowed to dispute. And that, again, sort of goes back to the same issues that I've already raised in terms of the types of prior bad acts that were admitted into evidence over my objection, the restraining orders especially, and then the elimination of major parts of our defense.
Could I ask one other question that, with respect to the last issue that you raised, the consciousness of guilt? Are you taking the position that the judge didn't have discretion to reopen the evidence to admit a stipulation of which everyone was already aware after the closing arguments had been given?
It's more, Judge, that Hightower, and it's not my strongest issue, and it's a technical issue. It's number one, I don't think the court can reopen evidence in that circumstance. But more importantly, the issue in Hightower is an issue of notice. And so the way that the stipulation was drafted and the way it came into evidence indicated that the defendant was present in court and then defaulted. That doesn't exactly explain the notice issue that the court in Hightower stated that had to be introduced, that the defendant had notice, in this case, that the case wasn't done for the day or he had to stick around or he had to stay. One could say it's a poorly drafted stipulation and it should have been drafted better for the Commonwealth to meet its burden. But from our perspective, just Hightower in the case law seems to indicate that something more specific was required. It was not in that stipulation, and the court should not have done.
Would you have been making that Hightower argument if the stipulation had been admitted before the close of the argument?
I think, in retrospect, yes. I think it's still, the stipulation still doesn't satisfy the Hightower requirement. So it still suffers from the same problem of a lack of notice, and that's how the Commonwealth was electing to proceed. Like I said, I think it's an issue of being careful of how, if a party wants to introduce a stipulation, and I think the court was right to insist that a stipulation be entered and not the docket sheet, which would have had much more prejudicial information. So I agree that a stipulation would have been appropriate, but it's not on the defense to help the Commonwealth figure out how the stipulation should properly read to meet their burden.
Understood. Thanks.
And if there's no further questions, thank you so much. I would ask the court to reverse the defendant's conviction and remand it for a new trial.
Okay, thank you.
Thank you, Your Honors.
We'll hear from the Commonwealth.
Good morning, may it please the court, Catherine, the Commonwealth. I'll first start briefly with the restraining order issue. I think it's well established that prior bad acts to establish the ongoing hostile nature of the relationship or motive to assault are permissible reasons to admit prior bad acts. I would suggest here, otherwise it would seem like it was an inexplicable event about why all of a sudden he was doing this. The victim testified to that this was continuing and ongoing from 2012 on, and that even though the first restraining order occurred in 2012, and then there were 2 others that occurred in 2014, that the emotional and abuse kept ongoing, and so it was continuous, and these were examples of patterns. To the extent that there was no limiting instruction, I, of course, as an appellate attorney, would prefer to have there been a limiting instruction. That being said, though, it was not requested, and it is not required that a judge sua sponte give a limiting instruction absent a request. That's Oliveira, 74 Mass Appellate Court 49. And I would distinguish this case from Mills, which was cited by my brother, where there was no limiting instruction there. And the reason why there was error there is that the jury came back with a question saying, can we consider this for propensity or something along the lines of that? And the judge said, give whatever weight you want to it, which was not the correct answer. It just said, no, you can't consider it for propensity. So I think that's a distinguishing factor. And to the extent there was error, this evidence was extremely fruitful evidence to help add further support that this was fabricated, that this victim weaponizes the court system to get what she wants. She wants the defendant out of the house, restraining order. She wants custody of the kids, restraining order. And so this was important evidence for the defense, and I would suggest there was no prejudice because of that. And also the jury didn't just accept this, that he has propensity to do this, because they didn't just wholesale accept everything that the victim said or accept all the charges as they acquitted on assault with a dangerous weapon. So as far as the restraining order issue, I would suggest there was no error, but even if there were, it's not a reason to reverse the case. If there are no further questions, I'm sorry if I went too fast, I speak quickly. If there are no further questions on that, I would address the expert testimony. I think the import of the judge's ruling after listening to the voir dire was that because, as admitted by this nurse, that she's a triage nurse, she doesn't diagnose and treat, that she's not qualified to say that this is what these are the actual injuries that you would see, because she doesn't diagnose and treat. Whether or not, based on her experience of being a nurse for a very long time, and that this is semi-common sense, I think, about what injuries somebody who is going to suffer from an assault, whether she could have been qualified to testify to that. I think the fact that, based on her testimony, as Justice Hand noted, it depends on the victim, the type of assault, the intensity of the assault. So there's no real, quote-unquote, common symptoms that you're actually going to see. And to the extent that this evidence should have been admitted, I think her testimony, based on the voir dire and what she said, she didn't testify that the CAT scans are always going to show internal bleeding or internal swelling or any of that, which was kind of what my brother argued below about why it was necessary, because the medical records didn't show that. The medical records, as explained by her, explaining kind of the medical terminology, show that she had a lot of these symptoms that she had testified to at the voir dire. At the voir dire, volume 2, page 7, 3, and 10, she said, you would see pain and swelling, maybe difficulty moving neck, red marks, hoarse, and the medical records. In my record appendix, which in my impounded record appendix, page 9 through 10 and 13, 15, 16, 35, and 36, and I did move to transmit those medical records because
And we got them, actually.
I hope they're more clear. They just kept, they kept degrading every time I reproduced them. But it showed that she exhibited swelling, red marks, difficulty speaking. She had swelling to her jaw, which would be consistent with a punch or maybe a slap. The red mark on her neck, and abrasions and contusions. So to the extent that this should have been allowed in. I don't know how much it would have actually helped the defense.
How do you respond to Attorney Masfer's argument that he was not permitted to even argue common sense inferences, but the Commonwealth was?
Well, I do think, I'm just looking, so I believe it's transcript volume page 37, where he made the argument, if she actually suffered this type of attack, there would be a whole host of corroborating evidence in those medical records that would be swelling. I will admit that the judge did sustain that objection and said disregard what you can draw from those medical records, but then he went back and said, use your common sense. When the Commonwealth says medical records corroborate, where's the medical expert to say that you can see redness, no bleeding? Do we see anything that indicates injury? None. How is that possible? She's to be believed. And he originally sustains that objection, but then he allows it in and allows them to consider it. So, I think he was able to make that argument, and to the extent the judge limited it a little with the prior instruction, I think that might have been a little bit of error, because I do cite cases that there's kind of common sense about what what injuries you can see, but in terms of saying whether or not the jury was able to look at and see that there was swelling and bleeding in the medical records. And at the end of the day, there was very strong evidence that this assault occurred. If there was error in saying the jury couldn't make that consideration, where there was the 911 call that corroborates the victim immediately with the tenor of her voice, the responding officer responding almost immediately after the assault, seeing her on the ground, that her mouth is, she has blood on her face, she can barely talk because she's in pain, her pants are pulled down. They have a photograph, although she does have a little bit of medical intervention. And then also the medical records that do show there was trauma, and that was her primary diagnosis.
Is there an absence of swelling in the medical records?
No, in the medical records, they talk about, I believe in the EMS records, they talk about swelling to the jaw. Appendage page 9, not able to fully open her mouth. I note it in my brief, I'm having trouble finding, but I believe there is noting that there's swelling, specifically in the EMS records, because it says enema to the maxilla, which is enema, as explained by the defense expert. Enema, I believe, is swelling, and maxilla is the jaw, and so she explains that, and I believe I can direct you to the page in the transcript. Yep, so volume 2, page 86, as she reads the medical records, it shows edema to the maxilla, which is swelling to the lower jaw. It talks about not able to fully open her mouth. Yeah, so the medical records show that there's swelling at the time, closest in time to when the assault occurred. And there are red marks, and then throughout the medical records, and those red marks on her neck, and abrasions on her chest and torso, and on contusions. So there was corroborating evidence from multiple steps, from the EMS, from the initial intake, and then through the final assessment.
And the nurse Kennedy, she was an after the fact. She was not a precipient witness. She didn't examine the victim herself.
No, she was the defendant's expert,
Right.
and so she was able to explain the medical records and the terms within them, which I think was helpful. So the jury was not left to speculate what they were.
Is it sort of a rational thing that she's enough of an expert to be able to explain to the jury what the medical records say, but not to be able to say what common symptoms are?
Well, I think the difference is when she only testified in court and as an expert because she primarily just reads medical records. So reading medical records and what they say and understanding them, I think, is different than saying somebody who comes in who's been assaulted is always going to have these injuries or symptoms. So I think that's the distinction the judge was making. But again, even if she should have been qualified as an expert based on her experience, it's not testimony I think that necessarily would have assisted the jury or was necessary. It's not that an expert testimony needs to assist the jury. And again, also, because it's common sense, but also her testimony at the end of the day from voir dire was, it all depends. And so it's not that helpful then. I'm happy to answer any other questions the court may have.
Seeing none, again, thank you both. Again, another well-argued case. We've had some really good arguments today. I hope that the civil lawyers are paying attention. We'll be back after a 15-minute break.
Court all rise, please. Court is now in recess.
Me to turn on the mic.
Oh, yes, please. Hang on. Microphone's not on.
Try now.
Testing. 1, 2, 3. Testing. 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 1, 2, 3. Testing. Testing. 1, 2, 3. Testing. Nothing? Okay, let's call and we'll get some more. Testing, 1, 2, 3, testing. Oh, we got it. It's working. He's got it.
Court, all rise. Court is open, please be seated.
Okay, we're back in session. The next case is 23P1405, Department of Children and Families versus Father. This is an impounded case, so please, let's not use any names. We'll speak to father, son. We've got father, son, and daughter, right?
No, Your Honor. I'll clarify that if you don't mind once I
Please.
introduce myself. Good day, Your Honor. Jennifer DeFeo, may it please the court. I do represent the appellant father in this case. On February 16, 2024, I certified with the appeals court clerk that I notified the appellant father of the inclusion of a Moffett preface in his brief. I provided him a copy with the brief and addendum, together with a copy of Commonwealth versus Moffett, 383 Mass. 201, 1981, and care and protection of Valerie, 403 Mass. 317, 1988. The brief itself also contained a Moffett preface that this brief was filed at his insistence. At the time of the alleged neglect, Your Honors, there were 2 children subject to the jurisdiction of the juvenile court, a son and a daughter. At the time of the trial, but before the submission of this brief, the son turned 18 years old. Today, the daughter still remains under the age of 18.
So does that mean the decree with respect to the son is moot?
Yes, it is, Your Honor.
Okay.
At least that's my understanding of the case law as I've read it. In accordance with the guidelines outlined in Commonwealth versus Moffett and care and protection of Valerie, I have disassociated myself from this brief with the exception of the very limited issue which I will address unless the court has specific questions. The trial judge was required to articulate specific and detailed findings in support of his conclusion in the termination of father's parental rights, and that it was appropriate. In doing so, the judge was required to demonstrate that he gave the evidence close attention. That's under adoption of Nancy, 443 Mass. 512, 2005. The judge's subsidiary findings had to be supported by a preponderance of the evidence, and ultimately the findings had to be proven by clear and convincing evidence. DCF had the burden of proof throughout this matter. The judge in the juvenile court made numerous findings of fact that were clearly erroneous and demonstrated that he did not give close attention to the evidence. The court credited the testimony of the social worker, yet he disregarded the contradictions in her testimony from the records that were presented during the trial. Findings of fact 137, 139, 145 to 148, and 150 were contradictory. The father detailed the contradictions in his brief on pages 16 to 20 and 23 to 26. Under Commonwealth versus Moffett and the care and protection of Valerie, I disassociate myself with the father's requested relief. He seeks that the court determine that the juvenile court judge's findings were clearly erroneous, and as such, this court should reverse the juvenile court's decision to terminate his parental rights.
Attorney DeFeo, could I ask a question? One of the arguments that I think your client makes is that it was clear error for the judge to find that the father did not engage in any of the action plan tasks that were assigned to him. Is that correct?
It is correct, Your Honor.
Part of that, at least as I understand it, is an argument that the requirement that the father participate in a psychological evaluation and provide releases was clear error. Is that
Your
true?
Honor, as for the psychological evaluation, it was impossible for him to do so because the jail in which he was housed did not provide him the opportunity, and DCF made no efforts whatsoever to engage an outside resource to conduct that evaluation.
So that's my question, I think. Is that argument really a reasonable efforts argument and not a clear error argument? He didn't do those things, but your client's position is that the department didn't give him the opportunity to do them or facilitate his ability to do them. Is that correct?
That is a reasonable efforts argument. The lack of clear attention to details, however, goes to the evidence in which the social worker testified that she did not provide father with any releases. Yet the judge found that she did. The judge also found that she sent him multiple copies of the Family Action Plan, up to 5 or 6, where the social worker herself testified that she might have sent him 2 and might have emailed his attorney 1 or 2. So while these are small details, what it does show is the judge failed to do his obligation to pay close attention to the details. And for that reason, Father believes that the termination should be reversed and that the matter remanded to address multiple issues, such as the issues pertaining to the best interest of his daughter, his proposed completing plan for his daughter, and whether the determination that he was unfit was premature because the criminal case was still pending. So
What is the status of the criminal case?
it's still pending. And if there are no further questions, I would rest on my brief.
Seeing none?
Thank you.
Thank you.
May it please the Court. Monica Murphy for the Department of Children and Families. I will be splitting my time equally with Child's Counsel. I'm here today to ask that you affirm the lower court's decision, which was to find father currently unfit to parent his children, as well as to issue a decree terminating his parental rights. I would like to start, if I may, with agreeing with counsel that because the son in this case is over the age of 18, that the decree is now moot. It is not effective.
Or the appeal of the decree is moot?
The appeal of the decree
Okay.
is moot. That is correct. So I would agree with that. But it is still viable as to the daughter. I don't want to get into all the details that are contained in the DCF brief. I certainly would rest on that brief, but I would like for one moment to address the challenge regarding reasonable efforts. The court did hear some conflicting testimony from the social worker in this case about what efforts were made to engage father in services, to engage him in this case in general. And some of the testimony was different, but I wouldn't say that it was completely contradictory. It just wasn't always the same when asked on direct and when asked on cross. The court did what it needed to do. It heard the witness, the social worker, it reviewed the documentary evidence, and it also heard from other witnesses, including father. Based upon that, the court came to certain findings of fact and conclusions of law, and I submit to you that they are not in error. The court found that there were action plans devised and shared with father, that certain services were asked of him in those action plans, and that he did not complete any of them.
Was there any evidence to suggest that the father had the ability to obtain the psychological evaluation that was part of the action plan?
There was evidence that he could have engaged in some evaluation, not necessarily a psychological. There was actually some testimony from father himself that he engaged in some kind of mental health evaluation. Clearly, in this action plan, there were some things that the department could not make referrals for because he was incarcerated. And I submit that the record shows that there was really a lack of ability on the department's part to organize services for father. But the department tried, and that's what reasonable efforts are. It's very fact-based. It's based upon the facts of this particular case. And certainly this court has reviewed that before, as has the SJC. And that's how one needs to look at this. And the worker did talk with father, a conversation that went very poorly and had to be cut short because of father's aggressiveness on the phone call. The court made that finding. And in that conversation, that was a conversation in which the department was attempting to speak with father about his children in foster care as well as what services would be required of him. The court also made findings that the department sent several letters to father, attempted to contact his caseworker. Unfortunately, none of that worked. And here's why the court ultimately, its finding that reasonable efforts was made should stand. Father himself testified, and the court so credited. He testified at trial that he did not need any evaluation, any therapy, or anything, that there was no unfitness. His only unfitness could possibly be a medical condition, but nothing else. And that was a central concern of the court, that father could not even see or even be open to the possibility that he might have some culpability in this matter, that he might have some accountability, and that he might need some help. And unless there are any further questions of the court, I would rest on the DCF brief.
Seeing none, thank you.
Thank you.
Good morning, Your Honor. Jacqueline Parker for the daughter, whose date of birth is April 3rd, 2008. The son did reach 18 and join the Marines last July. If there was a case where there's clear and convincing evidence of current parental unfitness, this is it. The father came to the mother's home where the grandmother had lived with the mother for many years to help with the children, beat up the mother with a pipe, the grandmother with a pipe, tied her up, put her in the bathroom. The garage door was open. When the mother came home, he murdered her with a pipe and a hammer. And then he proceeded to light the house on fire, thinking that the grandmother was in the home. And the grandmother somehow managed to get herself out into a neighbor, and the police were there watching him light the couch on fire. The family dog did die in the fire. The father has charges of murder, home invasion, kidnapping, arson of the dwelling house, armed assault in the dwelling, and assault and battery with a dangerous weapon. The judge found that the father has not demonstrated the ability or willingness to remedy his parental unfitness. The probate court judge had ordered the father, he had monthly supervised visitation, had ordered him to take an anger management class, which he said he didn't need and didn't do. Consequently, he hadn't seen the children for over 5 years because in the divorce decree, the divorce judge granted him no visitation because he wouldn't take the anger management class. Clearly, he didn't cooperate with that service. As far back, page 45 of my brief, Exhibit 10 at page 10, the father has a history of inability to engage in services. For example, the couple's marriage counselor had to terminate the second session because the father was disrespectful. Clearly, this father had no interest in engaging in any services. The judge found the father's display of callousness, aggression, and anger at trial was evident to him. It is abundantly clear that to this court that the father is unable to provide for the children's basic needs in any way, and he is not capable of appropriately assuming parental responsibility in the future. And his anger spilled over into his treatment of the children. The probate court judge found, for example, that the daughter told the father that her tooth was wiggly and hurt, and he responded by saying, "You're tough," and he pulled her by that loose tooth. The daughter told the social worker that...
How old was she at the time of that incident? How old was she at that time?
This was during the divorce, so she was about, 5, young, 6. The daughter told the social worker that the father hits me a lot of times in the face and legs. And the daughter said the father picked up the son by the head, and she stated that her mother tried to stop him, and he did the same thing to her on one occasion. And the mother described the same incident. This is finding of fact 22, findings at page 7. After he finally put the son down, he pushed the mother forcefully into a chair, and she testified she didn't call the police because he was afraid of what he would do if she did call the police. The children were also present when on September 21st, 2014, the father became angry when the daughter wanted to have her doll sit at the family breakfast table, and he went after the mother with a vacuum cleaner attachment, and he broke the French doors. That's finding of fact 22 as well. Another example is when the mother was in the car with the son about to take him to the orthodontist, and the father physically took the son out of the car and kicked the mother because the mother hadn't told him about the orthodontist appointment. The father has a long, long history of uncontrolled anger and inability to take any services for them. He not only lacks insight into his violent and disturbing behavior, but he also refuses to even have a conversation with a social worker without becoming aggressive and going off topic.
When a child turns, how old is it when the judge credits their opinion of where they want to be? Or is it like, right, I mean, is it when you're 12 that the child's opinion starts to matter?
I think at that age they have a right to say they don't want to be adopted, but they don't have a right to say, they can tell the attorney and the social worker where they want to be, but the department decides where they go.
Okay.
Okay. I want to just emphasize that in care and protection of Rashida, 488 Mass 217 at page 222, 2021, although the department is statutorily obliged to make reasonable efforts toward reunification, the means of fulfilling that obligation is within the department's discretion. And furthermore, the court may determine that the department has failed to meet its reasonable efforts obligation, but nonetheless determine a parent is currently unfit and commit a child to the department's custody if the court concludes that doing so is in the child's best interest. Clearly here, termination is the child's best interest. Reasonable efforts is irrelevant. He murdered the mother, he assaulted the grandmother, he set the house on fire. He's had opportunities from the days of the probate court to take an anger management class and try to, and he's not interested. He doesn't think he needs that kind of help. The children witness physical abuse, such as with a vacuum cleaner attachment. The father also abused the children. And Ms. H, the co-guardian, who had been the mother's friend since the kids were in kindergarten, refused to be ever near the father, and she told the department about the tooth wiggling incident because it was when he was picking up the daughter from her house that
Okay. Attorney
she
Park,
saw him.
you've got the red light now. I think we understand your argument.
Okay.
Thank you.
The father's
No,
rights
thank
must
you.
be terminated. Thank you.
We'll take the case under advisement. The next case we're going to hear is 23P663, James DECOULOS versus Board of Registration of Hazardous Waste Site Cleanup Professionals.
Good morning, Your Honors. May it please the Court. My name is James J. DECOULOS. The case before you is about whether the Board of Registration of Hazardous Waste Site Cleanup Professionals provided me a full and fair hearing in determining whether I should be disciplined for my professional conduct. The board is often referred to as the Licensed Site Professional Board, or LSP Board. As an opening matter, I'd like to address one of the two issues on appeal, which is whether the administrative action was arbitrary, capricious, and not in accordance with law. These arguments were raised in the trial court, and they're clearly within the scope of the original judicial proceedings. They are not new, and they have been preserved for appellate review. See the supplemental appendix 57 to 58. The board has cited the unpublished decision of 27 Ramsdale Avenue on page 39 of their brief, is one of the reasons why I should not be entitled to continue pursuing my arbitrary and capricious argument. Unlike the pro se defendants in that case, this action is not barred by res judicata. There are many facts and arguments I've made in my pleadings, but I would like to focus on 3 specific issues. Number 1, the denial of witnesses. Number 2, denial of evidence. And 3, the delay in the proceeding. As to the denial of witnesses, there were 3 witnesses in particular who were critical to examine and confront. Thomas Potter was an employee of the Massachusetts Department of Environmental Protection who conducted a field audit of the Eagle gas station in Carver in 1998, prior to my involvement. I deserve to confront Potter on whether he looked for a stormwater collection system within the right-of-way as a potential pathway for the prior gasoline release, and determine whether there was a threat of migration to a nearby river.
I don't quite understand how what Potter did, which was 5 years prior to when you got involved, why is that, 5 years later, is it still relevant?
Because he failed to identify a stormwater collection system in the right-of-way. And it was that stormwater collection system which was a key evidentiary issue in this case. That stormwater collection system was in place at the time of his field audit. He should have noticed it was a potential preferential pathway, and he should have inspected it and found out where it outletted.
But I mean, weren't the same facts still in existence 5 years later?
And those facts, upon my observation and findings, were that there was significant contamination, historic contamination within that collection system.
So his testimony would have shown?
His testimony would have asked whether or not he even bothered to look at that preferential pathway, and looked at where it may have outletted into this river. Now that would have. Now my examination of him would have clearly addressed these issues of this field inspection if he understood that there was a stormwater collection in the right-of-way, how it may have worked, and where it may have discharged. The underground system, as I said, is referred to as a preferential pathway in the Massachusetts Contingency Plan because underground contamination finds the path of least resistance, which is many times the pervious backfill that is filled around this piping. The presiding officer denied my effort, and I subsequently filed an offer of proof, Volume 7, 44 to 45.
Mr. DECOULOS, were you required under the board's regulations to file at least an indication that you had made an effort to obtain a written summary of what the proposed testimony of the witnesses that you're challenging were?
No, but I did explain what the testimony would have demonstrated in my offer of proof at Volume 7, 44 to 45.
Okay, is your answer no, you weren't required to do that, or no, you were required but did it in a different way? I just don't understand whether I asked the question.
I'm sorry, Justice.
I said I may have asked the question poorly. My understanding was that part of the department's concern was or the agency's concern was that you had failed to provide the written testimony, which the hearing officer could then decide whether or not to allow you to call the witness live. Am I understanding that procedure correctly from your point of view?
No, it's not.
Okay, then
Yep.
pass the question.
Fred Sivian was another department employee who was the state stormwater coordinator. He ensured that streams and rivers throughout the state were compliant with the U.S. Clean Water Act. Sivian helped develop the LSP licensing program in the early 1990s. He was one of the few department employees who understood how stormwater contamination interacts with an LSP's duties under Chapter 21A and 21E. Sivian's expertise in both stormwater and hazardous waste management should have been heard, but it was denied. My right to hear him was denied, and the right to issue a subpoena. None of the
he was not. He was, as opposed to Potter. Sivian didn't have any personal knowledge about the site. You wanted to call him basically. You wanted to use him as an expert.
That's correct.
Okay.
He had a wide breadth of experience and knowledge about stormwater.
And so is he a DEP employee?
That's correct.
So does DEP have to provide you with experts?
That's correct, and that's one of the reasons for my argument why I felt as though they were a necessary party, Your Honor. My offer of proof explained what.
Well, no, even if they were a party, are they obligated to provide you with expert testimony to help you make your case? I mean, like, I could see why if he was actually a precipient witness, that he actually had some knowledge of this case, that'd be useful, but it seems like each party sort of has to bring their own experts to the table.
Well, I mean, these issues...
And did you want, I mean, as I understand it, the reason that you wanted to present Civian is basically to say that you disagreed with the directives and denials of your proposals by DEP, that they were doing it wrong and they should have done it your way, and Civian would have supported your way.
That's correct. And these are national issues that Civian knows about. And this is, one of the key evidentiary issues here was a catch basin down gradient of this gas station the source of the contamination of this outfall? And if you look in volume 5 through pages, say, 678 through 727, you're going to see a wide range of evidence that I introduced regarding point source pollution under the Clean Water Act, the NIPDES permitting program, the town of Carver's obligation to comply with NIPDES, non-point source pollution, the Commonwealth's efforts to address stormwater pollution at catch basins. That was all there, and it was my conclusion or my opinion that Civian would have made all of this more aware to the presiding officer.
Before we continue with your other witnesses, and this is, I think, related to maybe Justice Hand's question, weren't you required under CMR to attempt to either show cause why you couldn't get pre-file testimony or to offer pre-file testimony?
From these two witnesses?
From these witnesses, yes.
No. No, I had no right to. I mean, the department obstructed me from getting any testimony from their employees. Jonathan Hobble was the last witness who I thought was the ultimate decision maker for the department. He was which was related to Eagle's liability, and he signed the approvals and denials for response actions. He was the regional engineer for the department with a unique level of understanding of engineering concepts, greater than his subordinate, Cynthia Barron. I needed to confront Hobble on his reasoning for rejecting 2 proposed cleanup plans I proposed and why he was adamant about installing an interceptor trench in the middle of a busy public right-of-way. Volume 4, pages 544 to 545, and you can see my offer of proof at volume 7, 46 to 47. Now, the 3 witnesses for the board, on the other hand, had no expertise in engineering, underground storage tank systems, stormwater collection systems, or wetlands protections. Board witness and DEP employee Cynthia Barron is an epidemiologist by education and training, volume 1 at 198. Witness Robert Lours is a hydrogeologist by education and training, volume 4 at 254. Witness Ian Phillips is a forensic chemist by education and experience, volume 4 at 291. None of the board's witnesses who testified in the Eagle gas matter were professional engineers, nor did they have any expertise regarding the construction or function of a municipal stormwater drainage system. Mr. Lours did not understand basic engineering principles, and it was exposed during my cross-examination of him in volume 7 at 870 to 883. Public and private stormwater utility design, planning, and investigation are the sole domain of professional civil engineers. See General Laws, Chapter 112, Sections 81D to 81T. The failure of the board to issue subpoenas for witnesses I sought is an unequivocal right that was violated under the provisions of General Laws, Chapter 30A, Section 12, parenthetical 3. Now, as to the denial of evidence, I was denied all email communications I requested from Ms. Barron and Mr. Hopple related to the Eagle gas station during the administrative proceeding. The presiding officer also withheld and sealed email communications I sought from department employee John Fitzgerald. See volume 7 at 352 to 372, and my second offer of proof at volume 7, 488 to 491.
These were all DEP, Mass DEP documents?
Yes.
And the argument that the agency makes, at least as I understand it, is that those weren't their documents. They weren't in possession, custody, or control of them. What response do you make to that?
The argument, Justice Hand, was there was a deliberative process exemption, and they were exempt from disclosure. You can see that in volume 7, page 309 to 310. This is an environmental agency designed to protect the environment, and they're not being transparent about what is being made available to the public. This evidence was important because at the time of my work, the department relied on the historic and ineffective tank and pancake model that was improperly used to evaluate the migration of light non-aqueous phase liquids, or LNAPLs. The hidden record in this administrative proceeding was ultimately unsealed in the Superior Court, and it demonstrated that in January of 2010, the department recognized that the tank and pancake model they previously relied upon was outdated, volume 15 at 79.
What was unsealed? Did you ultimately get the email, the DEP, these deliberative process things that were initially?
Right. What was unsealed was the recognition an admission by the department that this old method of assessing and addressing LNAPL contamination in the ground was incorrect. That they realized that they needed to address LNAPL in a new way. And the LSP Association provided 2 white papers that I cited in my brief. I also demonstrated that the tight silt and clay soils prevented an effective active mechanical recovery of LNAPL. The unsealed record also demonstrates that the department knew that LNAPL in similar soils was not likely to be recoverable. See volume 15 at pages 266 to 282. The failure of the board to provide crucial evidence for my defense is an unequivocal right that was violated under General Laws, Chapter 30A, Section 11, Parenthetical 4. Now, to the delay in the proceeding. It took more than 13 years for the board to investigate, adjudicate, issue a final decision in this matter. The board claims that a portion of these delays were my fault. Well, let's examine the dates and the relevant actions. On December 13th, 2005, my disgruntled client files a complaint against me with the board. 5 years after the complaint is filed, an adjudicatory hearing commences on January 26, 2011. 18 months later, recommended decision issued from the presiding officer on September 7, 2012. After nearly 1.5 years, the presiding officer requests a status report, volume 8 at 774. Now, the board's regulations state that, quote, the board shall endeavor to issue final findings of fact and rulings of law within 90 days of the filing or refiling with the board of the recommended decision. This is at 309 CMR 710, parenthetical 2, which I provided on page 136 of my brief. 1,031 days passed after the recommended decision before the board finally issued its findings of fact and rulings of law. 941 days late, volume 8 at 795. After another 1,291 days pass, the board issues its final decision on January 16, 2019. Now, 2 months ago, I notified the court of the recent Supreme Court decision, Loper Bright Enterprises versus Raimondo. Now, it's possible that this case may have spelled the doom for the well-known Chevron doctrine, Chevron deference, and it clearly was directed to the Federal Administrative Procedures Act. I understand that it has no applicability to the Massachusetts Administrative Procedures Act, which I'm before you here today on Chapter 30A. But Chevron deference was a two-step process. First, is the relevant statute clear? And second, is the interpretation reasonable given the specialized knowledge and expertise of the agency? I suggest that you look to this two-factor process as a guide and ask the same questions for this case. In the relevant statute here, Chapter 21A, Section 19H, is that statute clear on how the board will conduct an adjudicatory hearing and appoint an impartial officer? I suggest that the answer is a resounding no.
Can I ask you a blunt question? It seems to me that if you put this, just take a step back a bit, and look at this thing, that the reason that the board recommended discipline for you is that the DEP employees who are in charge of these sites say to do one thing, and you don't do it because you think they're wrong and you're right. And you try to convince them that you're right, and they say no, and you continue to resist what they say. That seems to me that that's what, and a lot of your argument here goes to that they were wrong, that ultimately you were proved right. Is that a fair assessment of what's going on?
No. No, I resisted initially.
Okay.
But after 2 failed submittals, I gave up. And I said, what do you want me to do? And so that's where we sat down with my client in Lakeville at the southeast region at the DEP and said, okay, I gave it 2 shots. I'm not going to get a 3rd strike. What do you want us to do? And in December of 2004, we did exactly what they asked us to do. So, you know, I tried my best. I tried to exercise my professional judgment as I'm supposed to be doing under Chapter 21A, Section 19. And there's a clear definition there of what a waste site cleanup activity opinion should be, which I encourage you to look at. But I was stymied, and I didn't want to continue to resist. I wanted to do what they felt as though I should be doing.
And as I'm not the AG's brief left this sort of up in the air. Your suspension has been stayed, and is it still? It's still stayed.
That's correct.
So the suspension from when was it? When did it go into place? In
2019.
Yeah, has not yet, never been implemented.
That's
so
correct.
you've been continuing to practice as an LSP all this time.
Yeah, but yes, very minimally. Yeah.
Have you changed professions or?
No, I'm a civil engineer as well, and a lot of my work involves wetlands protection, traditional site engineering, civil engineering, appearing before planning boards and conservation commissions. So that's a large part of my work as well. So I mean, I continue to practice on those areas.
Okay. Well, you know, for a non-lawyer, very good brief. I know I read the transcript. Pretty good cross-examination too. So we'll hear from the board. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Assistant Attorney General Christine Feminari, on behalf of the appellees, the Board of Registration of Hazardous Waste Site Cleanup Professionals, and the Commissioner of the Massachusetts Department of Environmental Protection. The Court should affirm the Superior Court's decision below, which dismissed the claims against the Mass DEP Commissioner, and the Court should also affirm the Board's decision below because Mr. DECOULOS has not met his burden of demonstrating that the Board's decision was invalid and prejudiced his substantial rights. There's 3 main reasons why the Court should affirm. First, as a procedural matter, the Superior Court properly dismissed the claims against the Mass DEP Commissioner because the Board is the only proper party to this action, which is a claim for judicial review brought under General Law, Chapter 38, Section 14. Second, there were no constitutional violations in the administrative proceeding before the Board. And third, the Board's decision was not arbitrary or capricious. At the outset, Your Honors, I just want to address the issue of the DEP Commissioner, because that's a discrete issue. Mr. DECOULOS named the DEP Commissioner as a defendant in this case, and that was improper because in this type of judicial review under Section 14, the only thing being reviewed is the final agency decision, which was issued by the Board. The Mass DEP Commissioner was not involved in that. And so regardless of how the Court rules on the rest of the arguments, we would ask the Court to affirm the Superior Court's dismissal of the Mass DEP Commissioner. And Your Honors, I think I'll just respond directly to Mr. DECOULOS's arguments in the same order. I would highlight that Mr. DECOULOS in his appellate brief made these arguments under the category of arbitrary and capriciousness, which is not the argument that he made below. So I do make a waiver argument, but I understand that Mr. DECOULOS is pro se, so if Your Honors would like to find it appropriate to engage in the merits, I can address those. Mr. DECOULOS contends that he was denied the ability to subpoena witnesses, but as indicated in our briefs and as reflected in the hearing officer's decision that denied the request for subpoenas, which is at Record Appendix Volume 7, page 13, under 309 CMR 7.08, which is included in the addendum to my brief, there's a requirement to file pre-file direct testimony, and in order to get an exception to that, you need to show good cause. Mr. DECOULOS did not make that showing. The hearing officer also found that Mr. DECOULOS did not show that the evidence of these individuals who he wished to subpoena was relevant or necessary to the proceeding.
How can he do a pre-file of testimony from witnesses that are in the department that the board isn't permitting him to subpoena or to talk to?
So, Your Honor, he would have had to submit something showing that he was that he had made efforts to obtain the testimony and that he was unable to do so. But in addition to that obstacle and deficiency, there was the finding of that the testimony offered was not relevant. And it's important to note that the hearing officer did allow Mr. DECOULOS to subpoena one Mass DEP employee, Mr. Jablonski, whose evidence he found was relevant. At Record Appendix Volume 7, page 44, the hearing officer provided the explanation for why each individual Mr. DECOULOS wanted to subpoena did not, the evidence that he had proffered was not relevant.
Why not Hobble, who was approved and denied these various proposals or whatever filings?
Yes, Your Honor. The basis that Mr. DECOULOS proffered at that Record Appendix Volume 7, page 44, for wanting to call Mr. Hobble was to get testimony about Site A in the late 1990s, and that was not relevant to the findings at the present time. Additionally, Your Honors, Mr. Hobble was a supervisor of Cynthia Baran, and Cynthia Baran was called as a witness for the board, and Mr. DECOULOS was able to cross-examine her. So she was also involved in those decisions. So I'm happy to go through each of the individual...
But he was also not permitted to look at the emails between her and Hobble.
I'm sorry, Your Honor?
He also sought the emails between her and Hobble, and that he was denied as well.
Your Honor, the only emails that Mr. DECOULOS were denied were documents that were not in the possession, custody, or control of the board. The board and Mass DEP are separate entities by statute. They operate separately. And so the board's response when these documents were requested was that they were not in the possession, custody, or control of the board, and I believe the citation for that is in my brief. I think it's in Volume 6, where the board has that answer. So that's the only thing that Mr. DECOULOS was denied. And
but the board is an adjudicatory body, right? I mean, they're acting on recommendations from DEP, right?
I don't believe so, Your Honor. The board is an 11-member board. One member is either the Mass DEP commissioner or their designee, and the rest are appointed by the governor. So while they might be acting pursuant to DEP regulations...
The evidence that they're considering is generated by DEP.
Yes, Your Honor. Yes, I'm sorry if I misunderstood.
Oh, no, yeah, my bad. But so they're considering evidence that's generated by DEP, but yet they're saying, but you're not entitled to that evidence because we're different from, the board is different from DEP.
No, Your Honor, I'm not sure I understand. The evidence from DEP was submitted to the hearing officer for this administrative proceeding. The hearing officer, by the way, is from a separate entity, the Office of Administrative Dispute Resolution, I believe, OADR. So whatever evidence both sides submitted, including testimony from Mass DEP officials and documents from Mass DEP officials, was presented at the hearing. Does that answer your question, Your Honor?
Yeah.
Okay. So additionally, Your Honor, Mr. DECOULOS mentions that there was a delay in this procedure, and we can't shy away from that. We can't deny that this took a long time. The complaint was filed against Mr. DECOULOS in December 2005. An investigation team was formed and conducted an investigation, and it took until January 8th, 2010 for them to issue the order to show cause. But in order for delay to be a basis to reverse the board's decision here, Mr. DECOULOS would have to show that he had been substantially prejudiced by the delay, and he hasn't done that. For one, Your Honor, as he noted, he has had his LSP license throughout the entirety of this proceeding, so he has not been prejudiced by being unable to practice as an LSP. And I will note, Your Honors, that at the time that I filed my brief, there was a footnote indicating that Mr. DECOULOS was not currently an active LSP. If you click on the link in the footnote, you'll see that he has since been reinstated as active. So I did want to just correct that as a factual matter.
That he was active or not? I couldn't hear you.
At the time that I filed my brief, his license had lapsed, and then under the regulations, you have an opportunity to renew your license after a certain period of time after it lapses, and he did renew it, and so he is active.
Is it reasonable to infer that if there's a 20-year shadow essentially on the license for Mr. DECOULOS, even if he's unable to show, for example, a decrease in, or that any particular potential client turned him down based on that, the existence of this pending litigation, for lack of a better word, is that a reasonable inference to make?
I don't believe so, Your Honor, because all that it shows is that there's a complaint pending. It doesn't show that there, has been a suspension issued or anything like that. All that shows is that there's a complaint pending. And so I don't believe that that's a reasonable inference to make, and I don't believe that Mr. DECOULOS has met his burden of showing that he has suffered any sort of substantial prejudice, reputational of that nature, as you're suggesting. Additionally, Your Honors, Mr. DECOULOS brought up the idea that there might have been a loss of memory of the witness of Mr. Jablonski, given the time period of the proceedings. But again, he has not shown how that would substantially prejudice him. The hearing officer in this case issued a very lengthy final decision, which is at Record Appendix Volume 8, page 703. And then the board, in substantial part, adopted those findings, and the board's findings and facts are Record Appendix Volume 8, page 797, and they go through the evidence that was presented by both sides. And there's evidence of violations based on testimony that was presented at the hearing, and the hearing officer considered Mr. DECOULOS's countervailing testimony and explained why it wasn't credible or why there was other evidence that caused him to make the determination that he did. And we would encourage the court to defer to the credibility determinations, the inferences, and the weight of the evidence drawn by the hearing officer.
Is there anything in the record that shows Mr. DECOULOS' attempt to appeal directly to DEP for the documents he sought?
I'm sorry, Your Honor, I didn't hear the end of your question.
So Mr. DECOULOS sought documents from DEP from the board, and the board said they're not under our custody and control. And is there anything in the record that shows he sought those same documents directly from DEP?
Yes, there is, Your Honor. Mr. DECOULOS submitted public records requests to Mass DEP, and I believe that's what he was referencing when there was some discussion of deliberative process privilege. I believe that there is a discussion of that in the hearing officer's denial of the subpoenas, that he requested those public records. But that's outside of this proceeding, Your Honor, whether Mass DEP, had to provide records pursuant to the public records law or not. Your Honor, just briefly, because it was raised in Mr. DECOULOS' brief, there's no constitutional violations here. He argues that there was a due process violation, but again, the delay does not rise to the level of a due process violation because it did not result in substantial prejudice. He was not denied the right to a fair hearing. There's implications in Mr. DECOULOS's brief that the hearing officer was not impartial, but the hearing officer came from the different entity, the OADR, and in fact, Mr. DECOULOS was represented by counsel throughout the hearings before the hearing officer. It wasn't until after the hearings had ended that he became pro se. So at no time did his counsel file anything to disqualify the hearing officer or to suggest that there was bias. And finally, Your Honor, to the extent Mr. DECOULOS argues that the denial of subpoena requests violated his right to confront witnesses, there's no right to confront witnesses in this type of civil proceedings. Unless Your Honors have any questions, I'll rest on the brief.
Seeing none, so a few days ago, our colleague Jim Milkey retired, and since Jim's not here, since Judge Milkey is not here, I'm going to channel him and say that sometimes at the end of these cases he would say, you both seem like reasonable parties, and maybe some discussion of, and there were settlement discussions at some point in this case, and maybe revisiting those discussions might be a good idea, but that's entirely up to you. Otherwise, the case is submitted, and we'll take it under advisement. Well presented on both sides.
Thank you, Your Honors. Thank you, Mr. DECOULOS.
Okay, our final case for this afternoon is 23P1133, Allure Design Landscape Architects Construction Services versus GINA Valandre.
Testing, 1, 2, 3, testing. Can you hear?
Sounds fine.
Okay, good.
Can you hear me, Mr. Cohen?
I can.
Okay.
All right, if it please the court, my name is Herbert Cohen. I'm representing the appellant in this matter, Allure Design, and I'll briefly give you the background. Allure is a landscape construction company. It's essentially owned by a Paul Karanen. Mr. Karanen was the sole shareholder, but not the sole officer. His girlfriend, Gina Valandre, I believe, occupied one of the offices, one of those offices, which thus prevented Karanen from having total control over Allure. All right. Karanen and Gina Valandre became emotionally involved, boy and girlfriend, man and girlfriend. Karanen was a landscaper. He ran a fairly big business, employed about 25 people. Unfortunately, he had some weaknesses. He became drug addicted and alcohol addicted. He would, in an effort to support that habit, he engaged in larcenous activities, appropriating deposits without doing the work. which ultimately led to a criminal conviction. But however, the issue of this case is that Gina Valandre was in the boarding horses business, teaching people to ride horseback. She had 2 pieces of property on Circuit Avenue, I believe, in one of the towns. And at some point, Kynes Corporation, Allure, became involved in improving her property. The improvements total approximately $630,000. Kynes, at the same time, was guilty of larcenous activities where he misappropriated approximately $800,000 of funds of his customers. The $800,000 went through Allure and ultimately improved his girlfriend's property, Gina Valandre, of about $630,000 worth of goodies. The assessment of her property went from $1 million to $2 million.
So Attorney Cohen,
yes,
not to interrupt, but the issue really is, was there a contract or was this work gifted?
I'll get to that right away. Yes, okay. Allure sued to collect what it said was a contract for $630,000. The court found against Allure. The court found against Allure for 2 reasons. One was they decided that the claims were barred by the doctrine of issue preclusion because there was an underlying case brought by a farm. And the man's name, plaintiff, was Farm. He had won a judgment for $37,000 in the Boston Municipal Court, and he sued Allure and Conan, as well as tried to reach and apply assets of Allure and Conan that were lodged under the name of Gina Valandre. All right. At the time the lawsuit was brought by Farm, Conan was in jail, had no access to lawyers, and had no money. He defaulted, as did Allure. They both defaulted. All right. So the lawsuit was really brought by Farm, who had lost $37,000 because of Conan's larcenous activities, against Gina Valandre, claiming that she had assets. The court found against Farm and in favor of Valandre. The trial court found that the Farm case, which had found for Valandre, in effect was res judicata or a collateral estoppel. And on the issue of whether or not there was an actual contract between Allure and Valandre to pay Allure for the $630,000 worth of improvements, the court relied on a presumption that the allegation of contract with sums owed was valid based on that presumption. However, the court never really got to that issue because the court found that Valandre won based on res judicata for the Farm case below. So the issue really...
Sticking with the Farm case.
Yes.
Justice Wilkins found against Farm and in favor of Valandre.
That's correct.
Because he found that the services were a gift.
That's correct.
Right?
Yes, sir.
And if he had found that there was a bona fide contract between Valandre and Allure, then if that had been the finding, then Farm would have been able to reach and apply that account payable, right?
Well, but the judge below Wilkins never got to that issue. That issue wasn't, oh, I'm sorry, the trial court never got to that.
Yeah, no, it didn't have to, because Wilkins decided it.
Well, the problem is that...
So you can't, I mean, separate from the question, I mean, the underlying questions in the FOM case, those are decided. I understand you argue that you didn't have a full and fair opportunity in the FOM case because your client was not represented. But you can't really challenge the underlying finding of the FOM case. If that's res judicata, you can't relitigate that.
But it's not res judicata, sir. It's not res judicata. It doesn't meet the test for res judicata.
Okay, so why not?
All right. The reason why it doesn't is because there has to be, first of all, to start with, Carnan and Allure defaulted. They never filed an answer. Carnan himself attempted to vacate the default, but was not successful because Judge Wilkins wouldn't allow that to happen. All right. That's not res judicata. There's no full litigation of the issues of those cases. All we have is the defaulted defendant that never filed an answer, and that is not res judicata because it doesn't cover the merits of the case. However, later on, Carnan is subpoenaed by FOM to testify at trial. And that is the issue. That's the issue that brings us here today. The trial judge found that there was a fair opportunity to litigate those issues because Carnan was subpoenaed to testify. The trial judge is not wrong. They're absolutely wrong. That's not what happened. I was there. I was the attorney that was brought in by Carnan to represent him while he testified subsequent to the subpoena that was issued at trial. And I can tell you what happened.
And he was testifying at that point as a witness, correct?
No, I'm testifying as a lawyer based on the briefs.
No, I'm sorry. Mr. Carnan was testifying at that hearing as a witness, but as a defaulted party,
That's
right?
correct.
Okay.
But he wasn't allowed to litigate. He was.
And you weren't permitted to cross-examine. You weren't permitted to speak, right?
I wasn't allowed to do anything.
Right. Okay.
In fact, I wasn't allowed to represent him. The court would not allow me to represent him. The court would not allow me to look at documents that were presented to him for him to testify about. They wouldn't allow me to object. They wouldn't allow me to redirect. They wouldn't allow me to tell a story.
Attorney Cohen, what part of that was before the summary justice judge, Judge Squires Lee? The transcript was not before her.
Well, wait a minute.
Was not part of the record, correct? The FOM transcript?
In a way, you're right, but not fully. I'll explain that to you. First of all, we put all this in the brief. It was all put in our brief. We briefed it fully, all right? And I'm the attorney that was there. So I certainly knew what I was talking about if I'm telling the truth, and I'm bound to tell the truth. All right. The other side had no idea what went on. Their brief is full of conjecture as to what went on. They're guessing. We're not guessing. I'm telling you what happened. Also, I want this court to take judicial notice of the transcript. And I believe the court has the right to do it under, let's see, under the Gerard's case.
I think we have, I don't disagree with you about that we can take judicial notice, but we cannot consider things on the summary judgment that weren't provided to the summary judgment judge.
But I did provide it. We did brief all this. We did explain to the summary process, to the summary judge.
I mean, what I hear you saying is that even without the transcript, the record below was enough to establish that you weren't permitted to represent.
That's correct.
Okay.
That's correct. So there was no full. It's res judicata or collateral estoppel or issue preclusion, whatever you want to call it, if there's a full opportunity to litigate the issues. And that if that had happened in the FOM case, then the trial judge is right. But it didn't happen. Essentially, Judge Wilkins took the position that because Carnan had defaulted and tried to remove the default, with Judge Wilkins denying that opportunity, he was still under a default, and therefore He didn't have, Judge Wilkins went so far as to say that Connor didn't have a right to have counsel.
What was the basis for Mr. Carnan's motion to vacate the default? On what ground did he want to vacate the default?
Well, I wasn't counsel at that time, but it's my understanding was that he was without funds and without access to counsel.
But it wasn't a lack of, at least I'm not recalling, that it was a lack of notice. Is that true?
I can't answer you.
Okay.
I don't know. I don't know. I think it was a lack of, I just think that Wilkins probably took the position he had the opportunity to file an answer and didn't. And Wilkins sounds to me like a strict judge, very strict. That's what it sounds like.
It sounds like what? I'm sorry.
She's strict, strict
understood.
in handling these matters. So when I finally appeared as Conan's counsel, at the time that he was subpoenaed to testimony, the judge took the position that Conan didn't have a right to counsel. I didn't have a right to represent my client. I didn't even have a right to even see a document that was put under his nose to testify from. I wasn't allowed to see it. I wasn't allowed to object. I wasn't allowed to function. That's basically what happened. And Conan couldn't, there was no redirect, so there's no full litigation of the issues. All that's happened is that he summons a witness and he answers questions, and that's all he's allowed to do. He's only allowed to answer the questions. That's not a full litigation of the issues. That's nothing. There's no litigation. He's just simply a witness limited to answer questions that are asked.
Attorney Cohen, your time is brief here. I want to ask you, Attorney Rosenthal makes an alternative argument why we should affirm the grant of summary judgment, is that the summary judgment materials failed to establish a contract that failed to and he argues that that Karenan's affidavit is a sham affidavit and contradicts his deposition testimony. How do you respond to that?
I respond by saying that the court took the position there was a presumption in favor of the fact there was a contract and some due. And that issue was not fully ever explored because the court was relying on the res judicata, improper res judicata.
But we can affirm on any ground that's apparent on the record. And he says the summary judgment record, we should look at it and say summary judgment should have been granted on the merits. And he says that the only factual dispute is based on an affidavit that we should reject, and that it's based on and also that it's based on hearsay.
Well, the problem is the court also hasn't determined whether or not there was a valid contract, there was any sums due, or whether Valandre got any benefits out of this.
But we can. Okay,
if the court can, then I would point out that the court cannot make that judgment because the gift was the result of stolen property over which Conan had no dominion and no right to make a gift. And on top of that, at the time that Wilkins found that it was a valid gift, the jury had found that Conan was insolvent. An insolvent man cannot make a gift, and over property he has no dominion over because he stole it. He has no control.
The summary judgment materials that were submitted in this case before Judge Squires lead, that's included in those?
Absolutely.
Okay. Well, your time is up. We'll have to take a careful look at the documents. But we'll hear from. There's some more questions. Oh, sorry.
Attorney Cohen, I just had a question whether you're conceding that your client's affidavit is contradicted by his deposition testimony.
I don't concede. I'm not going to concede. One of them, if there's conflicting testimony, then one part of it is true and one part may not be. But I'm saying the affidavits are true. Thank you.
May I proceed?
Yes.
Good afternoon, Your Honors. Stephen Rosenthal for GINA Valandre. We're asking that not only that the Suffolk Superior Court summary judgment be affirmed, but that this court determine that aspects of this appeal were frivolous and not filed in good faith. Let's talk about the affidavits first and the sufficiency of the evidence presented in opposition to Valandre's motion for summary judgment. Counsel for Allure argued in that motion hearing, and I'm quoting, "There was a contract because Gina Valandre agreed that she would pay the cost of what she received, that she would pay for the labor of what she received." And this is beginning at page 563 of the appendix. Okay? The judge asked, "And where is that evidence?" And counsel replied, "It's in the affidavits, apparently, and it's in all the invoices are also attached that would," and then the judge asked, "I have the invoices, but which affidavit will provide the evidence that she agreed to pay the labor?" Counsel said, "Well, you have the affidavits from Coronet." The affidavits, as was rightly pointed out, were sham affidavits contradicted by his deposition testimony under oath, in which he said he was in love with Valandre, he did the work out of love, he didn't bill her because he was in love and he wanted to impress her.
Although I did look at that, and he says that after he says, I did bill her for one invoice, for two invoices that totaled $300,000.
Well, let's put it this way, Your Honor. The complaint is based on 8 different invoices. Allure concedes that there was no written contract, that it was a verbal contract. Well, then there had to be 8 verbal contracts, not one, because you had 8 invoices that were prepared over the course of 2 years by Allure's admission. And in that case, what we don't have here in the affidavits is anything more than Coronet, whose credibility can be questioned.
But not for summary judgment.
But not for purposes of summary judgment, except for the contradictions in his own testimony. But you have Coronet saying, well, she agreed to pay, but there are no details. There's no, saying that she agreed to pay, that there was an agreement, is a conclusion that has to be buttressed by facts, that there was a meeting of the minds. There has to be some sort of discussion of, well, I spoke to her on such and such a date, we agreed to do this work, she said she was going to pay for it, and then 2 months later, we talked about doing this. None of that was in Coronet's affidavits.
It was in his deposition, though, correct?
Well, in the deposition, no, there was nothing about that in the deposition, about the 8 separate decisions to do work. I'm going to paraphrase Smyth and Zobel rules practice at section 56.6, who says that a useful rough test for evaluating the evidentiary sufficiency of an affidavit is simply if the affidavit were in court, the affiant were in court testifying word for word in accordance with the contents of the affidavit, would the judge sustain an objection on any ground whatsoever? If the answer is yes, or even probably, then the affidavit is at risk. That's certainly the case here, because you have Coronet testifying, well, these are the affidavits, and yes, I don't have the original records, but I called somebody named Monique who got onto supposedly a QuickBooks account, downloaded the stuff, created a new document, and mailed it to me while I was sitting in jail. And that is multi-level hearsay. Those affidavits were insufficient to defeat a motion for summary judgment. Now, the issue that my brother is relying upon is whether the issue was actually litigated, whether issue preclusion applies in this case. And we've talked about the FAM case, which was a reach and apply action by one of the people who had been deceived by Coronet to recover damages from Allure, Coronet, and Valandre. Well, you'll have to look at that reach and apply action and understand that that reach and apply action was based on an underlying judgment that FAM had obtained in Boston Municipal Court. The docket number is 1601 CV 001258. The court can take judicial notice of the docket entries in that case. There, Allure and Carnan were defaulted for failure to answer the complaint, but before final judgment could enter, an attorney entered an appearance on behalf of both Allure and Carnan. And almost immediately afterwards, Allure and Carnan entered into an agreement for judgment with FAM for the money that FAM subsequently brought this reach and apply action for. What's interesting about that is that the execution issued on August 8, 2017, 3 days later, August 11, 2017, FAM files the third-party action, the reach and apply action in Norfolk Superior Court. Now, they had an attorney.
What you just described to us, was that presented to Judge Squires-Lee?
No, Your Honor, I would ask you to take judicial notice of those docket
So you want us to
entries.
take judicial notice of it, that it's favorable to you, but not that it's favorable to him?
I missed the last part.
But you don't want us to take judicial notice of the transcript of of the proceeding?
Well,
don't you think it's, we should, yeah.
Okay, I'm willing to concede, but there's no evidence in the FAM transcript that is going to help Allure in this action for breach of contract. All of that had to do with whether the money was under contract or some sort of deception on Valandre's part, or whether it was a gift. And Judge Wilkins, as you pointed out, indicated that it was a gift, and that settled the issue because Allure and Carnan had the opportunity in that first case, the underlying FAM case, to bring in Valandre to raise those issues and didn't do it. And then they had a second bite at the apple in the reach and apply action. They could have asserted a third-party claim or a contract claim against Valandre, and they didn't do it. So, Allure was represented by counsel in the underlying case and had an incentive and a full and fair opportunity to bring a third-party claim against Valandre on the same contract theory it tried in the case underlying this appeal, but they failed to do so. Valandre had the incentive and opportunity to sue Valandre in the Boston Municipal Court and failed to do so. And that being the case...
What incentive opportunity do they have to litigate that where they're defaulted and which really is between FAM and Valandre?
Well, I'm sorry, you're talking about the BMC case?
Yeah, no, I'm talking about the one that you assert is res judicata.
Well, in the reach and apply action, that's how I identify it. In that case, again, they had the opportunity to, in fact, Carnan attempted to have the default removed, and I would direct the court's attention to docket entry 34 in that reach and apply action, in which Mr. Carnan wrote a letter to the clerk's office and stated in part, "My ex is concerned that she is in the middle of me and the plaintiff," meaning FAM. "She is not at all involved or was ever involved in any part of my business and never will be." Okay, so there you have another contradiction between what Carnan is saying in these defective affidavits and what's in statements that he's making to the court and statements that he's making under oath at a deposition.
Whether we rely on the transcript or what Attorney Cohen represented in his briefs or his oral argument to the summary judgment judge, how can you argue that that's a fair opportunity to be heard in the reach and apply hearing? The judge essentially told him he had no standing. He didn't let him make an objection. He bristled when counsel wanted to see, he didn't allow him to look at exhibits. So how is that a fair and full opportunity to be heard?
Well, you have to understand, Your Honor, that in that underlying FAM action, they had attorney. They had an attorney who represented them, who entered into an agreement for judgment. And then 3 days later, this new action is brought, and suddenly they don't have an attorney until Mr. Cohen shows up at the actual trial. If I can just go through the chronology for 1 second, I think that would help. That Boston Municipal Court case, that complaint was filed on July 15, 2016. The agreement for judgment entered and execution issued on August 8, 2017.
I'm objecting to this. None of this is in the brief.
Sorry, we're not in the trial court here. We'll be able to figure that out.
The reach and apply action filed 3 days later. Allure files this action in Superior Court on February 3rd, 2020, alleging breach of contract. Judge Wilkins enters judgment in the reach and apply action on January 28, 2022. 8 months later, on September 16, 2022, Mr. Cohen files a complaint in the Money Market Inc. versus Valandre, representing another creditor of Mr. Coronan.
We see that you attached that in your addendum, but that wasn't before Judge Squirely, was
No,
it?
it was not. I did mention it in my brief that that action was filed, that Mr. Cohen was represented the Money Market Inc. And in that, but what's significant about it is that in that case, Mr. Cohen was arguing that this was a gift. He wasn't saying it was a contract.
I was not arguing with this. I never argued that.
Well, you can read the complaint.
I'm sorry.
We will.
This is a misrepresentation of what went on.
Your Honor, I object to these interruptions. So I think if you understand the chronology of events here, may I have a little extra time just to make up for these interruptions? Thank you. So my argument in my briefs and in this oral argument is that the issue could have been and should have been litigated, but it was not, due to the actions of Allure and Coronan. And in this particular case, even if you agree with Mr. Cohen.
Let's get basic issue preclusion law. Doesn't there have to be identity of parties?
You have identity of parties.
Well, the judgment was for Valandre against FAM. There was no judgment between Valandre and Allure in the FAM case.
No, but Allure and Coronan were parties in the case. And part of what Coronan and Allure were arguing in the FAM reach and apply action was that she's the one who's responsible. She's the one that should pay. So there was an identity of parties in that case. I'd like to backtrack for a second here and go back to the alternate argument that was made here, because even if you determine that issue preclusion does not apply in this case, the appellant still has an obligation to present specific facts to rebut the motion for summary judgment that was brought in Suffolk Superior Court. And I think it's pretty clear that the affidavits that were submitted were conclusory, were based on invoices that were multiple hearsay, and were contradicted by statements that Mr. Coronan had made under oath. And for those reasons, I think that even if issue preclusion does not apply, which I say it does, they didn't get over the hurdle of presenting sufficient facts that needed to be resolved at a trial. And the fact that Judge Squires-Lee said, well, you know, I'd have to assume that what he says is true, what he said wasn't sufficient. Okay? So, for those reasons, and because some of the claims that were made in this appeal were frivolous. For instance, violation of Karenan's First Amendment rights, a right to counsel. Karenan isn't a party in this case. The notion that because Mr. Cohen was interrupted during argument on the motion for summary judgment, that was somehow a violation of his right to due process. No support in fact or in law for that argument. So for these reasons, and I apologize for the dry mouth, we're asking that the verdict or the summary judgment be affirmed and that you consider whether aspects of this case should be considered frivolous. Thank you.
Thank you both. The case is submitted. I want to thank the court officers and the clerk, and we'll be in recess.
Court all rise, please. Court is now in recess.